Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. Good to have you here. Let's start our day in Michigan with Judge Dad.
It looks like, first of all, she was charged with 3 different counts. She had OWI occupant second, less than 16, which, as you know, is a 5-year fine. She also had 2 other counts, which were consisting of, let me just give me a second here, which consisted of a charge of OWI second, that was set forth in count 2, which was also, it was actually a high BAC, OWI high BAC set forth in count 2. And then she also had a charge of operating while impaired second. As far as I can tell from my notes and everything here, she pled to OWI occupant less than 16, a 1 year. The felony count relating to the OWI occupant, as well as the super drunk. And Heather, I want to make sure that everything is reflected accurately. I did not make very good notes on the register.
Beth did come down this morning and speak
Right.
with Lisa about it. So I believe everything should be correct in the system now.
Right. So I also had, but I want to be clear about this. So count 1, there was a plea to the lesser included of OWI occupant less than 16, a 1 year. Count 2 was super drunk second with the prior, which is also a felony, that they went ahead and dismissed. And then count 3 was operating while impaired second, which they also dismissed, but a count was added of child abuse in the 4th degree. So I'm going to sentence, which is also a 1 year. So I'm going to sentence on the OWI occupant less than 16 and child abuse 4. I'm going to put it on our sobriety court register. As to OWI occupant less than 16, the terms are going to end up running concurrent. As to that charge and the child abuse 4th, and then all other charges will be dismissed. That being said, have you had a chance to review the report? Do you agree with all of that?
That's correct, Your Honor. Double checking. Yes.
Yeah, I mean, they did this on a little bit different form because it was sobriety court, and that's it. That's all I'll say about it. For the record, a victim's rights notice was sent to Mr. Hughes. I believe it's Mr. Hughes. Just give me a second. Yeah, Josiah Davis, care of Forrest Hughes. Is that individual here? That individual is not here. You can go ahead and proceed. Have you had a chance to review the report, and are there any material additions, corrections, or deletions?
We have reviewed the report. The stand has also reviewed the report. No objections or corrections.
All right. Anything you would like to say?
Very briefly, Your Honor, I sent, and I apologize, I just gave it to the court today, sort of a bullet point letter. And if the court doesn't have it, I have a copy I could give you right now.
I don't believe I've received that.
I will hand it to the court and I will summarize it very quickly.
Okay, you can hand it up.
Thank you.
Thank you.
Because although the pre-sentence report's accurate, Your Honor, the question is, why does this keep happening to Ms. Dan? And I think that's what I kind of lay out very quickly in my letter. She was, I don't want to get into too many details of the report, but she was the victim of some abuse multiple times as a child. And her substance abuse stems not from her desire to party or have fun, but to deal with this trauma. Which will segue into, she's aware of that. She was taking some medication to curb her ability to drink. Then she got pregnant and had to go off it.
The Vivitrol.
Correct, Your Honor. She has, since her arrest on this, been working on her addiction, but I think more importantly, the underlying issues, going to mental health counseling, going to meetings, going to family counseling, going to individual counseling. talking to her today, she says, every day she has some sort of meeting, some sort of therapy to go to. Recovery for her has been a full-time employment, really. One thing she wanted to do today, but she said she just couldn't do it, is read some letters to her children that she wrote. Those letters were both an apology for her actions, but also an explanation. And I think more than anything, what those did was help her understand the effects that her actions have on her children and how much they impact them. I've received calls and texts and support from her current boyfriend, who she has one child with, they're expecting her second one. He's committed to her sobriety and sober living. A very good friend who's been helpful in supporting her, giving her rides, making sure she gets where she needs to go. I think all these things show that she is really committed to her recovery. She appreciates, she's, I think, one of the few drug driving clients I've had that doesn't complain about the tether, the alcohol tether. What she says is, thank God I have this on because I can't use the Vivitrol. It's really helping me stay sober. The court has the option of sentencing her to some jail time on the child abuse fourth. I think given the progress she's made in her recovery, I think that would be counterproductive. We're asking for a non-custodial sentence on that. If she doesn't continue to make these great efforts, the court can at that time, I think, impose a jail sentence. But I think as long as she's working so hard, I think the important thing is to let her continue that.
Anything that you would like to say?
I'm pretty sure that the sentencing, the my baby's life. So I just wanted to say thank you for that. I'm really happy that I got caught that day. I'm 85 days sober. I go to a meeting every day. I do everything that I'm supposed to do. And I want to help other women like me once I start going through this program.
I'm sorry, I didn't hear that last sentence.
I just want to help other women like me once I start going through this program.
Well, I'm troubled. I'm going to tell you my negative comments first. One of the things, I've been sitting here quite a while now, and one of the things that I always think of is how do I say this delicately? It's an impossibility for our society to improve if we don't have parents that care them. Can't do it. Impossible. And I'm not saying every parent, I'm not saying majority of parents, but certainly there's a sufficient amount of parents out there that don't get it. They don't understand. They just don't understand. You can't have parents that don't care about their kids. Because when they don't care about their kids, kids are smarter than we give them credit for, even when they're 2 or 3 and they don't even know that they're thinking. And they know when they're loved and they know when they're not loved. And they know when people care and when people don't care. Now, I'm looking at this from and I told you I'm going to tell you the negatives part first. I'm looking at this and I'm saying, you have a young child in your car, and that child at the time, now you've got 5 kids and you're looking for a 6th, right? Right?
Yes.
And the child that was in the car was how old?
It was 2.
Okay. And you were pregnant when you were doing this, right? On its face, the child has no chance. On its face. No chance. I feel so poorly or badly about the fact that so many kids come into this world and they have no chance because they have parents that are not doing the right things. And I didn't say it's an easy job. I'm not sure any of us are equipped to do it, but it's certainly not an easy job. But we have to try. And we can't have kids when we're doing cocaine and hallucinogens and amphetamines and sedatives and inhalants, and now we're smoking marijuana and we're drinking. All of that, you don't need a legal scholar to tell you that. You don't need a substance abuse counselor to tell you that. You don't need a psychiatrist or psychologist to tell you that. You just need somebody with common sense to tell you. Just a little. They don't have to be overwhelmingly intelligent. Now, that's the bad news, because I'm just really floored by some of the things I read in. I really am. We just can't do this. We cannot do this. The good news is, I believe that you're sincere about this. But don't go out of here. And I'm telling you, I'm not saying you're going to be one of them. But I just have sensed, and I can almost see it when they leave the podium. There's either one, boy, I got lucky and I'm going to stick with it, or judge didn't send me to jail. I'm okay. Now I can let my guard down. There can't be any letting of your guard down. If I want you to understand that if you don't comply and make it through sobriety court, you will do a year.
I understand that.
I hope you do, because there will be no ifs, ands, or buts about it. There won't even be a consideration.
I understand.
Now, so far, you've at least weaned yourself off the marijuana. But I'm telling you, nobody can argue with me that alcohol and drugs being consumed by a pregnant woman is anything but horrifically bad for the child. And I don't know how to put it to you this way, but other than saying, I mean, kids are bigger than we are, right? I mean, we should be doing everything we can to make them successful, to make them have values, have integrity, work hard, making them understand the world doesn't owe them a living. I'm going to cut you a break, but I do not want you to walk back from this podium, because there's going to be a lot of requirements here. And I want you to understand, you violate, and you're going to get every single day I can give you.
I understand.
Do we understand that?
I do.
Now, the prosecutor's office, they come out with these things, and they wanted me to send you to jail in so many ways. I'm going to read it to you just to remind you what they said. Sentence agreement of 60 to 90 days is determined by the judge with work release if eligible. May be waived, jail condition may be waived at the discretion of the court if the defendant completes a specialty court program. Court can impose jail at its discretion for child abuse 4. The OWI 3 charges will be dismissed at sentencing. Really, it was an enhanced from super drunk, second, which makes it a felony, child occupant less than 16 with a prior, which makes it a felony. So there was no OWI 3, but they were enhanced and they were felonies. 2 years probation sentence agreement with sobriety, drug, veterans, or mental health court that the defendant will need to find placement on or before sentencing. No early termination. 33rd District program is acceptable. We think it's more than that. Full restitution, parenting responsibility should be included. Defendant fails out of the sobriety court or special court due to poor performance, commits another crime while on probation. The judge finds sufficient cause to terminate the balance of the year. 1 year must be served in jail. No work release or waiver. The above are recommendations only is what I made them mad. The court need not order 1 year in jail if the defendant does not successfully complete program. And I've gone round and round with them about that because they're not the judge. And they have the right to do what they want to do and enter in sentence agreements, but I don't have to go along with sentence agreements. I thought that was overly harsh, especially for somebody that might struggle and struggle and struggle and get to the end and violate, I'm not giving them a year. But I want there to be no misunderstanding. And I know I'm talking a lot because I'm troubled by this one. I want there to be no misunderstanding. You fall down on this, you're doing a year. Your lawyer has done a tremendous job for you. Did I let everybody finish? I'm writing the sentence if I did.
Yes, thank you.
Anything else?
No, yeah.
I'll get the count. I'm going to call it count 3. It should be child abuse. They're not adding a count. They're reducing a count from operating while impaired second, which is a 1 year, as far as I'm concerned, to child abuse fourth. 2 years probation. You cannot leave, but first of all, you have to comply with all agreements, guidelines, and requirements as indicated in the sobriety court participant handbook. 2 years probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs, and you're not to go to any place that sells or dispenses or alcohol, and I'm talking as its primary source of business. I'm not going to consider it a violation if you go into 7-Eleven and buy a Diet Coke, but you're not to go to any bars. You're not to go to parties where alcohol or drugs are being consumed or dispensed. You're to submit the chemical testing, PBTs and ETGs on demand of probation. We're going to pay for those tests as long as you go every single time, and as long as you test negative every single time. You test positive, you're going to end up paying for the test, and you're going to be incarcerated. You complete the recommending 60 days. I'm going to make it 90 days on the sober link. I know you have a scram. We're going to change the scram to a sober link. It's going to be on our dime now with our grant. You fail the test, you test positive on a test, you're going to not only be subject to sanctions, you're going to be paying for your own testing for a lengthy period of time. You're to attend 12-step meetings 3 times per week and provide written proof of attendance. You're to obtain an AANA sponsor. You're to attend all substance abuse treatment at a facility approved by probation. You're to attend the Victims Impact Panel. That is one night put on by Mothers Against Drunk Drivers. You are to attend and complete the Armed Specialty Court Weekend Program. You're to report to Sobriety Court status review hearings with me every 2 weeks. You're to meet with probation in the off week. You're to obtain and maintain employment with proof provided to the probation department. And this is all on count 1. This is all for the OWI occupant, less than 16, 200 fines, 200 costs, 75 victims' rights fee, $50 justice assessment. So that is 5 1/4. Your screening fee is $60 for 585. You have probation fees of $480, bringing your total to $1,065. You have sobriety court fees of $360, bringing your total to $1,425. Now, I'm going to order that you serve 11 days jail, credit 1. Actually, I'm going to order 15 days jail, credit 1 for 14. I'm going to allow you graciously to serve 10 of those days on the court work program. There is a $35 a day charge for that. You're going to serve the other 4 days by way of community service. You're going to serve 4 days of community service. I'm going to give you time to complete that, and that won't be, I'll give you all the way until May the 31st. You're going to have your hands full. You're to complete 10 days on the court work program and pay a sum of $35 for each day ordered. I'm going to make a note that that is $350 plus your $1,425. So your total here amounts to $1,775. Now, I'm going to talk about court work program fees in a second. All right. Now, if you violate, your probation could be revoked. You could be incarcerated for a year with credit for 1 day served and any other time you serve on the court work program community service. Defendant not to be completing court work. You're 5.5 months?
7 months.
7 months, I'm sorry. Not to be completing court work until not to be completing or starting court work program until at least 3 months after childborn. Your community service, I think you're going to be able to do one way or the other by May the 31. That's not taxing, and I'm not going to have you start on a court work program now. As to count child abuse, I'm simply going to indicate I'm putting you on the sobriety court for that as well. Sobriety court terms and conditions concurrent. This is on, and I want to make sure it's mentioned there, other sobriety court terms and conditions set forth in count 1 to run concurrent. So I'm basically ordering everything on this case that I just ordered on the other one. However, I am going to add a little bit of fines, but not much. Heather, I don't remember. Can you ask Amy? There's one of these, when it's a state case, we don't charge the victim's rights or justice assessment. I can't remember if I charge the 75 or the 50, but not both. So can you check with her if you don't know the answer, or Lisa, please? I'm going to simply go. So I'm not charging any other fees except to say 100 fines, 100 costs, and then you paid the screening fee, you're going to pay everything else, and I will either charge you 75 for the victim's rights or $50 justice assessment. So your total there is either going to be 275.
I'm checking right now.
Take your time, or 250. Again, if you violate, your probation could be revoked. You could be incarcerated for a period of 365 days with 1 day credit. Now, I just want to double check one other thing. They ran Forrest Hughes is who? Your boyfriend?
No, he's a friend of mine. He's just a friend. He just helps me out with rides and getting me.
Well, why did we send the victim's rights? He's not the father of any of the children, is he?
No, we were unsure as well. That's why he didn't have anything to say. He didn't know what to say or what to do. And when he called, he couldn't get a hold of anybody around.
All right.
Okay, Judge,
Yeah.
we charge the 50.
So it's $50, something. So it's the $50 judgment fee, justice assessment fee, for a total of $250. So you owe $250 plus you owe on this case, and I can't do much better than this, $1,775. So you owe $2,025. Now, I'm going to let you pay this case, the child abuse. I'm just going to give you a date of May the 1st. Can you do it by then? That's only $250.
I can do that, Your Honor.
And then I'm going to have you pay, and you can tell me if you can do this, but I need you to stick with it. $50 a week starting May the 8th.
I need you to say that again. I'm sorry.
50 per week beginning May the 8th. Can you do that?
Yes.
Pay 50 per week on count 1 beginning May the 8th. And if you ever need more time, you need to come talk to me. All amounts due by November 1 of 27. Okay? You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I'm not taking action on the immobilization since you didn't own the car. There's no evidence that the car owner allowed you to operate while knowing you were intoxicated, and that's what I'm going to do. You'll go meet with probation. We're going to switch out the scram. The judge said switch out the scram for Silverlink. And we're going to have to send a letter to the county because that's where she got it at. She got the scram tether at the county when the bond was set. Okay?
Okay, Judge.
All right. Thank you very much. Good luck.
Thank you.
Have a good day. Nice day to your counsel.
Thank you, guys. Appreciate it.
Curtis Brent Hamadi, 246R70167.
Good morning once again, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. Good to have you here today. I like Wednesdays. Ooh, a whole bunch of birds just flew by the TCF bunker, like hundreds. That's fun. Let's stay in Michigan, but let's go to Judge J. Cedric Simpson. Never heard of this guy before. Let's see what's up with him.
Who's approaching the bench? John, state your name.
John Duffy.
Judge, these are a series of cases from 2006. Mr. Cook is, pardon me?
You said these are a series of cases?
Well, I mean, serious, several charges from 2006. Okay, let me
So
back.
how many cases do you think I have?
One case.
Okay, go ahead.
Sorry about that.
I just-
Misspoke.
I thought there were more cases.
You be the understanding judge. You
All
already
right.
saw through it. Judge, we would just like to adjourn this out 30 days. There's Mr. Cook is endeavoring to get discovery from 2006 to see if we can resolve this.
I was 3. Go ahead, yes.
And you're going to see some reports from Pittsfield yesterday. I'm going to upload those and give those to the defense counsel and just make sure there's nothing additional that we might be missing given the age of the case.
You might need a hieroglyphics translator. So what's my date? Will that be enough time for you?
I'm sorry.
February 4th.
That would be fine, Judge.
During this matter, February 4th, 2026, 9 a.m. or your invite indicates bond will continue.
Thank you, Judge, for your consideration.
Court calls the case of the people versus Megan Matson.
Morning, Your Honor. Raymond Cook, people.
Your Honor, Michael Vincent on behalf of Ms. Benson.
Hello, your name?
Megan Maxon.
All right.
We are requesting a bench trial at a bench trial
All
date.
right. Good. Ma'am, you signed this waiver of trial by jury.
Yes, I did.
You understand that you have an absolute and constitutional right to have the matter tried before a jury.
Yes,
You understand that by signing this form, you'll have a trial, but it will be without a jury present.
I do, Your Honor.
People also waive their right.
Yes, Your Honor.
Based upon the statement of counsel, in the defendant court will consent to have the matter tried before it without a jury. Non-jury trial in this matter will be set for.
January 28th at 9 a.m.
Your Honor, I apologize. I'm actually set for a jury trial before Judge Rush Hour on January 28th. Is there?
So you'd rather be there than with me?
I would rather.
No, I'm just saying, you were assigned to this courtroom, and so you're telling me that you're going to be somewhere else with a judge that you like better. Is that what you're saying, Mr. Cook? I'll wait for your answer.
Your Honor, we'll waive his appearance. Okay?
Can you give me another date? Since Mr. Cook likes Judge Freshour better. Well, I like Judge Freshour better.
The next is February 25th.
I will be out of state, I believe, at that time.
No, it's not Christmas. You won't be anywhere. Is he gone?
Fortunately, well, no, actually, yes.
He is? Fine. So he'll be out of state. Cook likes fresh hour. Go ahead, give me another day. We'll try to fit it into all their schedules.
The next date is March 25th at 9 a.m.
Is that okay?
That works for the fun.
Of course, nobody has anything on their schedule. Well, hey, can you be here, Mr. Cook?
The trial's not that far, so I should be free.
Idiot.
Non-jury trial, March what?
25th, 9 a.m.
25th, 2026, 9 a.m. Bond will continue.
Thank you.
We'll see you in a quarter year. All right, take care. Court calls the case, People versus Albert Wilson.
Good morning, Your Honor. William Amadeo, P7619 for
I didn't even see you over there.
Sorry, Judge.
No, I would have.
Been working out, losing some weight. I hope this helped pay it off. Mr. Wilson, please state your name for the court. State your name for the court, Al.
I'm sorry to say,
Say your name.
oh, my name is Albert George Wilson.
All right, very good. All right, where are we on this?
Judge, Mr. Cook is now the prosecutor on the case. He did provide a potential offer.
Until he decides to go to another court.
Huh?
But go ahead. No, never mind. My bad.
With that being said, my client is 77 and I'm not sure he could do sobriety court and make it there. So I'm trying to come up with an alternative, maybe community service. I'm trying to keep him out of jail, obviously. I think we're close to resolution,
Okay,
but he's not able to drive. So I'm trying to make sure I don't set him up for failure.
okay. So you need an adjournment.
Like 3 weeks if I could.
My next date,
It'll be February 4th at 9 a.m.
will that work?
Yeah, thank you, Judge.
Adjourn the matter to February 4th, 2026, 9 a.m. Bond with its conditions will continue.
Thank you, Judge. Good
All
seeing you.
right, thank you. Good seeing you, sir. Court does call the case of the people versus Elizabeth Raggett.
Morning, Your Honor. Raymond Cook with the people.
Morning, Your Honor. Sam Bernstein with and on behalf of Ms. Raggett. Ms. Raggett, can you please say your name?
Elizabeth Raggett.
All right. Good morning.
We're just waiting on some information from the prosecution, Your Honor, and they're going to be sending that our way. So hoping for an adjournment.
Adjourn the matter February 4th, 2025, 9 a.m. That'll work for you?
Yes, Your Honor. Thank you.
All right, thank you. Thank you, Ms. Raggett. Court calls the case, people versus Austin Shepherd.
Morning, Your Honor. Raymond Cook with the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Shepherd, who I see on the Zoom screen.
Yes, Your Honor.
All right, state your name, please.
Austin Shepherd.
Okay, I'll excuse it this time. Next time, put on a shirt.
Oh, I'm sorry.
Anyway.
I'm hoping to adjourn for a potential resolution, Your Honor. Mr. Cook had talked to me about that a little bit this morning. I want to follow up.
February 4th,
Yes, Your Honor. Thank you.
2026, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you, Your Honor.
Putting on a shirt is always good advice when it comes to court. Shake my head. Whatever, I guess. Morning once again, everybody. It's the Courtroom Files live on a Wednesday. Good to have you all here. I want to take a moment right now and announce something new coming out of the TCF bunker. Actually, it's a joint venture between myself and that wonderful guest host that we had yesterday, Michael GROFF. We're going to be doing a channel starting February 2nd called In the Blind with Mike and Dan. It will be a live show. It will be every Monday and Wednesday evening, 8 p.m. East, 5 p.m. Pacific. It will be an hour long. And Mike and I are going to go into the show having absolutely no idea what we're going to talk about. Our producers are going to give us 2 subjects in real time, and we are going to debate, discuss, and break them down. And then we're going to have a special segment at the end where we're presented with kind of a rapid fire round of ideas or items or historical events or whatever the case may be. And we have to very quickly debate them and determine whether or not they were a real thing or if we're being lied to. Well, just make yourself comfortable, sweetheart. So anyways, it's called In the Blind. Barbara, you can go ahead and drop a link for that right now. What I'm asking you all to do is go over there, if you'd be so kind, and subscribe and hit the notification bell. Next week, we're going to drop a pilot episode, so you'll be able to check that out. And then once again, starting February 2nd, we will be live every Monday and Wednesday evening. And we're really looking forward to this. Michael and I have been debating for a couple of months now on doing a show together. And this one, I think, plays into our strengths because we both shoot real well from the hip, and nobody's quite doing it like this. Everybody goes into shows prepared. We're going into it with no preparation whatsoever. We will not know until you do what we're going to discuss, so it should be a lot of fun. So do me a favor, go over there and subscribe. And again, next week we'll have a pilot episode for you, and then February 2nd we'll start it officially. So thanks in advance for your support of our new venture. I know Michael's really looking forward to it as well, so it should be fun. Let's do this. We're going to stay in Michigan, but we're going to go to Judge Middleton. He's got a zoning hearing, and as I was glancing through it, people brought photos. So this is always a good time. Let's see what's going on.
Morning, Your Honor.
Montville Township versus David McGrew. File number is 2422570N. Attorney Aaron Geschwint is here on behalf of Montville Township, and Mike Hayden, their zoning enforcement officer, is also present. Doesn't appear Mr. McGrew is here. Hi, I'm looking for David McGrew for a zoning violation matter. All right, thanks. Bye. Doesn't appear that he is present. Good morning. first I almost blew the secret of Doug Coolman's retirement. You had a like panic look on your face.
Yeah.
I missed it. It was such a secret. Then I forgot to do it till it was over with. So my apologies both for blowing the surprise and forgetting to go. Were there any arrests made that night or was it all pretty?
I think it's coming up.
Oh, is it?
I think so.
No, I thought it was like the 30th. Maybe I'm not blowing it again.
No, it's-
I'm on the live. All right, we'll wait. We'll talk about it later.
Yeah.
Well, let's talk about this. This is a situation where the defendant had a trailer on a piece of property that was burned. And they were living in this trailer or motorhome on the lot at Cedar Court in Montville. There was a show cause order from last April that prohibited them from doing that. And this is a show cause of why they should not be found in contempt for failing to comply with that show cause order. Let me find this file. Ms. Geschwind, what's the status here today?
Thank you, Your Honor. The status is that the property is still not into compliance. The burned out structure is still on the property. It is not been taken care of. It has not been cleaned up. And so today I would be asking that the defendant have 30 days to go in and demolish the structure, clean up the blight associated with the cleanup. And then if they don't, then the township should be allowed to enter the property, bring it into compliance and charge the costs back to the defendant, as well as $480 in restitution for the unpaid fire bill, and then $225 for reimbursement for ordinance officer enforcement fees.
White Pigeon Township was really at the forefront of trying to collect fire costs. Mr. Hayden, as long as you're here, let's put you under oath. You swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief.
I do.
And are you the current zoning enforcement officer for White Pigeon Township?
Montville Township, yes.
Montville Township. It's a White Pigeon address, but yeah, it's
Yes.
actually in the little and non-incorporated village of White Pigeon. Now, you've provided some photographs that you took yesterday, and that's always very helpful. Are those photos true and accurate depictions of what you saw?
Yes. I would add that the motorhome is still there. However, they are not living in it.
All right, let's take a look. All right, we've got on the screen, it looks like a part of a burned out or frame of a house or building. What are we looking at in that picture?
That was taken from M103. That is the mobile home that burned in September of 24. And some debris and junk on the right-hand side of the photo there, next to a shed.
Yeah, so all kinds of stuff over here. So this is a mobile home?
Yes, single wide mobile home.
What are we seeing in this picture?
That is the same mobile home from a different angle on Cedar Court where there was an addition of some sort there that's with it.
All right, there's a building to the right, which doesn't look to be in that great a shape. Is that part of the same property or is that a different property?
That, I believe that is part of the addition that was on the mobile home. And then that's Bank Hardwoods in the very background of the photo.
All right, but this building that we're seeing on the right, where I've got the arrow
Yes.
on it, is part of this same structure.
Correct. Or very close to it on the one side.
And that needs to be demolished as well?
Correct.
Another view of the,
Yep, that's just a different angle of the same mobile home.
and then here's a little out of focus, but is
Yep,
this a
that's the-
mobile home in the back?
Yes, that's the mobile home in the back and the RV that they were living in, and then some debris and junk.
But no one's living in the RV. Is the RV plated?
No. And they have admittedly told me that it does not run. They would have to have it towed away.
And those 4 pictures were fair and accurate pictures of what you saw yesterday
Yes.
or Monday? I guess the date.
Actually, yeah, Monday, the 5th, I think is when I took those.
Photos of January 5th, 2026 are admitted as Exhibit 1. All right, Ms. Geschwind, they aren't here to argue about it. There appears to be plenty of trash and debris around there. Between your firm and Mr. Kuhlman and others, there's been an effort to clean up a lot of blight in Montville for 10 or more years. And little by little, it's being taken care of. Defendant is not here to address the issue. I grant the relief requested by the plaintiff. You may submit an order.
Thank you, Your Honor.
As a practical matter, 30 days from January 7th is February 7th, and probably not a lot would be accomplished in the dead of winter. But there's a 21-day appeal period. The defendant could appeal. It's unlikely they're going to clean this up. So it's likely that it's going to get cleaned up and the costs will be spread. Let me stop the live share. So 30 days to bring it into compliance. Or the township shall remove the debris, building, trailer, bring the property into compliance, spread the bill on the tax roll of that property. They're also allowed the $480 fire department partial bill, $225, which I'm sure is more than less of the actual cost of the zoning enforcement fees. So I'll await the order. And do you have any idea where the people are, Mr. Hayden?
I believe they're with a family member down in Indiana, Bristol or Middlebury. I don't remember which town. But they do still get mail at that address. Nothing's ever came back to me.
All right, thank you. Stay with me. I'm going to stop the live feed and the record, and I'll address some other matters. All right, I have a sentence at 10:30 and a sentence at 11. And I got
And he's done. So we had a little commotion in the studio while that was going on. This is part of a plastic bag with this lovely little handle, or paper bag rather, with this lovely little handle on it. And Ellie thought it would be a great idea to stick her head through that. And then she got caught. And then she started running and ripped the whole bag apart. The funny thing is that her sister Io did this very same thing a couple of months ago. She witnessed it. She saw the traumatization of Io through it, and she decided to try it anyways. So a little commotion here in the bunker, always a good time. Let's do Louisiana. Let's see what's going on there.
Time is 8:52 in the morning. The date is January the 7th of 2026. My name is Steve Prater. To my right is Jerry Ledoux. To my left is Chuck Tillis. We'll be handling the revocation cases today. And we're in the Baton Rouge headquarters of the Department of Corrections. With us this morning in the Department of Corrections is staff. Would you introduce yourself, please?
Jasmine Thompson.
Jalen Cavalier. Okay, thank you. Appreciate that. And we're talking to Mr. Trivial Charles. Is that correct? I think you may be on mute.
Correct, sir.
Okay, and you are at Acadia Parish Jail. Is that correct?
Correct, sir.
Okay, would the staff that's at Acadia Parish Jail introduce yourself, please?
Sergeant Martell.
Okay, Sergeant, thank you for hosting us this morning. We appreciate that.
Yes, sir.
Mr. Tavell, or Mr. Charles, Charles is your last name, correct?
Charles and Baptiste. Charles Baptiste. Charles is his last name.
Okay. Tell us what your full name is and your DOC number.
Trivial Charles Baptiste, DOC number 131909.
Okay. And do you have a form in front of you that you signed that waives all your rights as far as this hearing goes, and that you want to go forward with this hearing? Do you know what I'm talking about?
Yes, sir. I would want to go forward with the hearing.
Okay. Do you need to look at would you show us the form? Okay, you see the form that's right there?
Yes, sir.
Did you sign that form?
Yes, sir.
Okay, I appreciate that. Your case this morning has been assigned to Miss Jerry Ledoux to ask the questions and to interview you about it. So she is the lady on the right, and she's going to be talking to you from now on, and then we'll come back and ask some questions in a minute. So go ahead, Ms. Ledoux.
Good morning, Mr. Charles.
Morning, ma'am.
I'm going to be reading the allegations against you for violation of your parole conditions. And I'm going to ask you to enter a plea of either guilty with a statement, or not guilty. And then we can discuss the information after that, okay?
Yes, ma'am.
Condition number 3, you failed to return to the listed and registered address of 902 Locust Street in Rain, Louisiana, after moving 1/16/2025. You failed to communicate the change of address to the Acadia Parish Sheriff's Office within 3 days of moving from your residence. Your whereabouts were unknown until 3/10/2025, when it was determined that you were enrolled in the Woodlake Addiction Recovery Center. How do you plead?
Guilty with a statement.
Number 4, you failed to refrain from criminal activity by committing the offense of 1 count of failure to notify law enforcement of a change of address, residence, or registration information within 3 business days, which is a felony, resulting in the issue of a warrant. The warrant was signed, and then you have a new charge of failure to register, and your trial is 3/9/2026. How do you plead?
Guilty with a statement.
You are currently $1,451 in arrears on your payment. How do you plead?
Guilty with a statement.
Okay. Well, at this point, then I would allow you to make the statements on those charges.
Okay, thank you. First, I would like to expound on the fact that I went to the Wood Lake, what I've learned. I'd like to get this off first, that I accept full responsibility and all accountability for having such inconvenience right now that I've caused to myself, my parole officer, and the board. And since I was at Wood Lake, and I've learned that accepting accountability and taking full responsibility and the seriousness and the importance of me staying registered. I've been on the charge of registration for 36 years. I've never had this allegation against me. And I'm asking the board to show considerations on not revoking me on the account that out of the 36 years that I've been having to register, I've never been faced with this opposition. Second, I've worked my work ethics and my work history while being out. The 2 years I was out, I worked successfully 22 months, 28 days and 2 days off. I worked successfully. I also apologize to the board for another inconvenience that it's an honest mistake on the authority figures over here in Acadia Parish for letting me bond out. I did the very next best thing that I was taught to do from recovery, and which was contact my parole officer, Mr. Guidry. He told me that I wasn't supposed to be out, and I asked him what he would like for me to do. He told me the first thing he would prefer for me to do is go and update my address. I complied. I also complied with going to the Wood Lake. I was a bit late, but I complied. I successfully completed and participated. While out on bond, I didn't sit around and worry about the circumstances. I went and got a job. I went in Wood Lake with a job. I came back. I went a week or two and got hired at Popeyes. So I asked the board not to violate me on my production of being productive. I was a little bit late with some things. I dragged my leg, but I took, and I do take full responsibility and accountability, and I understand the importance of me having to register. And then if I am afforded a chance to go back, I have my job still waiting. The chance that I'm given, it will not return void. And I just want the board to know that I rest my soul on honesty, respect, importance, and responsibility. Thank you all for letting me talk and hear me.
Mr. Charles, if you had a job, why did you not pay any of your fees?
I started out real good with paying my fees, ma'am. I had the registration, the sex offender classes, they were $120, and I had this $65 a month. I started out good. The household that I was living in, it became unhealthy for me. We had an agreement with the what I should pay, which was be $500, and then it went up to $700, and it caused me to go backwards. And then it was, I was being used in the household I was at, telling me that this bill was this much. I never looked at the bills. I was in a very unhealthy relationship. So when it was time for me to make a decision and go to some of my classes, I wasn't able to pay. So I began to fall backwards. And it stressed me a great deal, the household that I was living in. I explained some things to my PO, Mr. Hunter, that I was going backwards at this household, and I didn't want to no longer be at this household. So he referred me to some help. I took the help. I got up and did what I needed to do. I got back under the covenant with God, and here I am now, ma'am.
You do have, I don't understand future fiance, but Donna Isaac.
Exactly.
Like to speak on your behalf.
Excuse me, ma'am?
Miss Donna Isaac would like to speak on your behalf. We'll let her do that now.
Ma'am.
Good morning.
Morning.
I'd like to address the board. My name is Donna Isaac. I'm a longtime friend of Trivial and future fiance. To my point of view, all of this was just a big miscommunication because of the simple fact through transferring to rehabs and being turned down for 3 different rehabs that they don't take sexual offenders, prolong it, Trivia's process. And upon him leaving and really learning who Trivia is, he did great in this. The rehab was the best thing that could ever happen to him. And also, he spent 34 days in the Washington Parish Jail, which the Crawley police came get him. They bonded him. They set a bond, and he bonded out. He updated his address as of April 30th. So when Hunter came to get him June 4th, he had already updated it. But Trevor, under his supervision, had told him just to lay low because they may come back and get you, which I don't think they would have come back and get Trevor because of the simple fact they already had their information with the registry. The fact that he stayed 7 months incarcerated now, I think it was a blessing from God because he really got his spiritual growth in him. Trevor is also, besides having 2 jobs that are still waiting for him, he's also been very active in his ministry with New Testament ministry under leadership of Pastor Cole. He also been volunteering with a mentor, Will Lowe, who has a treatment center in Crawley that he goes volunteer to. I don't think benefiting him to keep him locked up, I don't think it would benefit Trivial because now he has me in his life, and Trivial knows me. I'm a very spiritual guided woman. Also, by releasing him, he can catch up on all these fees. And basically, that's about all I can, I say it just was a big mistake to me. And he's carrying this charge for 30 plus years now with registering, and he was off parole 2013. So getting back into the same charge again that he never committed, it makes it kind of tough when you trying to find yourself. You're trying to find stability, and you're going in all the wrong places that you fall. And at that point, he took a fall because he was stuck between too many people advising him what to do and trying to do the right thing. So I asked the board if they would have mercy on Trivia and give him a chance to get back into society and prove the man that God wants him to be. Thank y'all, and y'all have a good day.
Thank you.
Thank you.
We do have Hunter Guidry, PMP agent, who would like to speak. Mr. Guidry.
I'm Hunter Guidry. Y'all have questions?
How was your interaction with Mr. Charles while you were supervising him?
For the most part, Charles was respectful until it got to a situation in, I believe it was January of 2025, after testing positive for some controlled dangerous substances. And then there seemed to have been a mood change and some things of that nature. He was then referred to treatment, which is kind of how this all came about.
So up until that point, he was compliant and no problems, basically.
Yeah, we had some issues with not sleeping at the correct address sometimes. We had some issues, I mean, realistically, nothing horrible, right?
Okay. So do you, in your opinion, as a professional agent, believe that his compliance with the treatment is going to setting back on the right course, or?
Well, it's I don't really have an opinion on that, honestly. The way I feel, what ended up happening was by policy, he was instructed to report to my office and come sign a notification of admin sanction agreeing to go to treatment. He failed to do that, at which time I had a feeling where he was, but he was not registering with the sheriff's office. It ended up in him getting a warrant, and then he did not go to treatment as when I instructed him to. He went afterwards, but he did complete treatment, and they did say he did well in treatment.
Mr. Charles, where are you registered to live?
Where do I register to live?
Yes.
I'm registered at Chaparral.
Currently registered. When you got out in April, you went and registered. And what address did you use?
The Chaparral address.
Okay. When you return to supervision or get out, where are you going to live?
I'm going to, laws had changed. Mr. Hunter was telling me when he brought me back into custody that the 1,000 feet doesn't apply to me. I can interact with my grandkid. So I'm going to live with my fiance, Miss Donna Isaac.
Okay.
Upon release.
I would like to ask for an executive session.
Second. Got a motion and a second for the executive session. There is no objection to it. At 9:08, we'll be going into executive session. We'll be back with you in just a moment. Just let us talk about procedural matter.
Yes, sir.
The executive session. I think I did good Cajun there. All right. Well, they discuss matters. Let's head back up to Michigan, spend a few minutes with Judge McNally.
How you doing, Your Honor? My name is Michael Benedictine.
Where you been?
Good, and you? I'm here today because
No, where have you been? You were supposed to be here in front of her. I'm back on December of 23.
Exactly.
It's 2 years. That's 25 months. Where have you been?
Correct. I am under the impression somebody may have used my name. This is my vehicle, correct? But a police officer let me know that I have a warrant, and don't even remember being out. So yes, I could have let somebody use my vehicle at the time. But I do not recall at all getting pulled over.
So you're charged with failure to pay $248. Is that the amount, Heather?
Yes, it is, Judge.
So you could be held in contempt. I'm just telling you the possible penalties. Then I'm going to make a suggestion. Up to 1 day for every $10 owed, you could get 25 days. You can satisfy this in full by payment, full by serving the jail term, or in part by payment, and in part by serving the jail term. Do you understand that?
There, one more time, you said that a little bit ago.
I'm sorry. You could get 25 days. If you pay $148 as an example, you'd only owe 100. You'd only have to serve 10 days. You can satisfy this contempt charge by paying it in full, by serving 25 days, or any combination thereof. Do you understand that?
I understand.
Did you sign an advice of rights form today and read it and understand it?
I did sign anything today.
All right. You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers, to quote, to bring in those witnesses, to testify or remain silent. If you remain silent, that silence will not be held against you. If you plead guilty, you give up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Right.
You have the right to a lawyer. If you want one, I will give you one. If you want a lawyer.
Court planning.
You work?
Yeah.
Where at?
Jail.
I'm sorry?
It's a plant in Pontiac. It's called Jail Corporate.
How much do you make there?
About 1,200 every week.
Every 2 weeks?
Yeah.
I'm going to enter an not guilty plea. Did you live on Ken Cross Ridge in Greenville, South Carolina?
Correct.
Were you living there in July of 23?
No, I believe I got that right.
When did you get back?
Not sure. It was 23 though. Might have been in the summertime. It was warm outside still on Saturday.
I'll give you a $500 personal bond. We're going to schedule this for hearing in front of Judge Hessen. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You understand all that?
Correct.
He's to fill out a petition for a court-appointed lawyer. You are going to get a hearing date. I want the officer here, issuing officer, to appear. And we'll have a lawyer for you. So fill out a petition. We'll get the officer to appear at a later date. You show up at the later date, and we'll give you a lawyer.
Okay.
Okay? What do you have for me, Heather? This is Judge Hessen's.
All right, let me take a look here, Judge.
All right, they're back from executive session. So let's go back to Louisiana and finish that up.
All right, the time is 9:12 in the morning, same date as when we took our executive session. Can I have a motion to return to regular session?
I move that we return to regular session.
Got a motion?
Second.
And a second, and there is no objection to it. So at 9:12 in the morning, we're going back into regular session with Mr. Charles. Okay, Gary?
Mr. Charles, you have a court date, March of 26, to deal with the failure to register charge. Is that correct?
Yes, ma'am.
Okay. Mr. Charles, my responsibility is to determine if society is at any risk with you returning to supervision, and if we can manage your supervision in a way that's best for society first and for you. So since you have received your substance abuse treatment, you have been able to articulate what you did wrong. You have been successful for a number of years in your registration, and this is the first time. My vote is to not revoke. And then you will go into court to deal with those failure to register charges. But Mr. Charles, I don't think I need to give you a lecture about the necessity of following the rules exactly. You won't get any more grace. Let me just put it that way from me. If you messed up again. But my vote today is to do not revoke.
4, okay.
I concur with Ms. Ledoux.
Okay, my vote also is to not revoke you. It's because of your history, your longstanding history of having completed your registration as you were supposed to, and the fact that you're allowed to stay with the grandkids and all that. It means it wasn't anything against any kids and all that, which would make a big difference with me. I appreciate the agent and your comments and the work that you've done trying to keep things between the ditches. And so you're not going to be revoked today. We realize you have a court date, and that's none of our really doings. But we're not revoking you today, and we'll leave it up to the agent to make sure that everything's on the up and up and that you stay straight. And we appreciate it. And that's the end of the hearing. It's 9:15.
Okie dokie, friends. That's how that one ended. What do I want to do? I got eyes on 15 different courts at the moment. There's actually a lot of court this morning. Probably the most we've seen since we came back from the new year. Let's do Judge Middleton. Let's go back there, though. He's got a sentencing.
A long time since I've actually seen him face to face.
That's the first time I've ever seen him.
Good passings, Pablo, pretty often.
Well, I use him by Zoom,
Yeah.
but I haven't actually seen him
Oh, yeah,
in
I've never
person.
met him in person.
I use him a lot and he's very accommodating, but I've never actually, well, he says we met some years ago and I guess I won't.
Someday you're gonna find out about Mauricio and you're never gonna look back.
Yes, I understand. That's quite a upgrade. All right, we are back. We've procured the services of Ross Truckee for 2 sentences here this morning on a Wednesday. Abigail Stoll is with us from the prosecutor's office. We have one matter set at 10:30 and one set at 11. So we're going to get right to our work. Where we are doing, what we're working on is People versus Caleb Brian Stainer. There are 2 files, 252330SM and 252434FY. As I indicated, Ross Truckee is here with the defendant and Abigail Stoll. The defendant entered a plea which resolved both of these cases. On November the 14th, he was charged with domestic violence and malicious destruction of personal property. The complaining witness in that case was Maria Baldridge. Miss Baldridge and Mr. Stainer have 2 small children together. Defendant spent 4 days in jail on that case before posting a bond. Bond was posted on November 17th. Defendant was arrested on, November 17th. He was arrested on the 13th. Then, a few days later, on November 26th, the defendant was charged with home invasion, 2nd degree, illegal entry, aggravated stalking, and interfering with a crime report. As part of a joint, in that case, he spent 10 days in jail. He was in jail from November 26th to December 6th. And then he posted a very large surety bond. Pursuant to the plea agreement, defendant pled guilty to malicious destruction of personal property less than 100. In file 252330 and to domestic violence and illegal entry in file 252434FY. All the other charges were resolved. The felony charges were dismissed. As I would usually do in such a case, I continued the matter to get more information and get input from the victim. So we've set the matter for today. I didn't get any victim input. According to Ms. Stoll, the prosecutor hasn't had any additional input from the complaining witness, and we're ready to do sentencing in these 2 matters. Mr. Truckee, what would you like me to know?
Thank you, Your Honor. Mr. Stainer, Mr. Stainer is 26 years old. He's employed full-time at Bill's in Bronson. He's from that area. He's residing in that area with his father now since these instances.
Which is where?
Bronson.
Okay.
My father's house or?
Yeah, your father's house.
It's in Billings.
Borough, okay. I know where Bill's is. I haven't been there in a long time, but what do you do there?
I am one of the more common broil cooks. I usually work on the broiler. So I
make lots of steaks.
I do. I mean, hundreds, maybe if not 1,000 a week.
All right.
So he's working there in that environment. He's got a 5-month-old and a 23-month-old, both of whom are sons in common with the complainant here. Complainant's 22 years old. It appears to me as an outside person that these are two relatively young people with two very young children and too much alcohol in their house. Both of these had alcohol as a component. Mr. Stainer recognizes that had alcohol not been involved, likely these would have resolved in a different way other than a shouting match, screaming match, domestic violence conviction, and everything else. Mr. Stainer was exposed to domestic violence as a child, and I believe he's now cognizant that that affects how he responds when presented with intermarital conflict. And that's something that he would be working on to resolve. As well, the alcohol thing. He's got here with him a few chips that he's earned since his second arrest.
What are they? 30-day, 10-day, 30-day?
It's the blue chip is for showing up the first time as the initial, and then yesterday at class, I got my 30-day chip.
All right, well, that's a good start. People have given some of those to me over the years, my little treasure box. But, all right.
He's continued to attend after his release from jail, which is really what counts to me. When you're in the jail, there's not much to do. And so getting out for a meeting's fine. But he's maintained that in Bronson, had a local church since then. And I believe that has helped his overall personhood. So his criminal history is limited. He was charged with an assault and battery with an acquaintance who Your Honor is familiar with. I'll not use his name unless Your Honor wants it, but that was dismissed at a later time in 2022 or thereabouts. Outside of that, there's not a criminal history to speak of. He's been compliant with his tether this entire time. I think that the main thing in this case is we have somebody that's 26, which I'm getting older, but that's on the edge of what I would call young. Okay. And that is definitely the time where put up or shut up in life starts to happen. And this is
tomorrow we'll either do Edge of 17 or 18 by Alice Cooper.
I'd go with the Alice Cooper song,
right.
Judge. I saw him in concert. And it's stupendous. But the quote he gave to me was he never had something kick me in the ass like this, because this is the time where it's like, am I going to live this DV drunk, bad example for the kid's life, or am I going to put it together and be a man? And I'm hopeful that Caleb is going to be a man now. And this is the time for that. So I'm asking that the court sentence him to a term of probation designed to continue his sobriety and treatment and help him resolve the issues that led to this incident and help him find what healthy relationships may be and what is okay and what's not okay and how to handle that marital stress. Thank you.
All right, well, who's in the Fawn River Road address right now?
Mariah.
And it's your father's house?
It's not his house. It's okay. So he has a friend from a long time ago. His name's Scott Plank. He lives 2-3 hours away from here. My dad oversees the property.
All right, so he's the property manager for the owner.
Yes, that's right.
All right, and I don't know if I have an estimate of the door jamb got broken, if I have a damage estimate.
I don't know if it matters, but I did put a new flange on the door and I did fix it when I got out of jail.
All right, well, that's relevant to me. Now, you've got two very small children, very close together in age.
Yes.
Does she have help with the kids? Are her parents nearby, or your parents? Or
her parents are not. My family does help quite a bit. Her grandparents help out here and there, but my family takes.
So right now she's at home with two very small kids.
Correct.
And at Christmas, you weren't able to have any contact with
No,
each other.
my mom, she did release them to my mom on the 24th for Christmas Eve, and I got to see them for a couple hours, but it's been pretty limited other than that. I had them the week that I was here, the 16th, and then I didn't have them for another week. Then I just had them again for about a week. So it's kind of week on, week off through my parents. They're going and getting them and bringing them to me.
Well, that's the best you can do under the no contact circumstances.
Yes.
Ms. Stoll, Mr. O'Bear and Mr. Truckee spent a lot of time on this, worked out this plea agreement. I'd hope maybe to hear from her, but what's your input here?
Well, Your Honor, the defendant may be young, but he is still old enough to know better than to assault the mother of his children. What especially concerns me is his actions in the felony file. He violated the conditions of his bond, showed back up at the house where she was staying, the victim. According to the police report, she tried to run away from him. She was running across the yard and he dragged her back towards the trailer. And at 26 years old, that's certainly old enough to know better than to treat anyone like that. I do believe probation is appropriate. I would recommend a lengthier term of probation, possibly 24 months, but ultimately I would leave it to the court's discretion.
Now, you didn't move into this house till July of 2026 or 2025?
Yes.
So you had two kids, but you didn't live together?
No, we lived together.
But you lived in a different place?
Yeah, we just came up on the trailer and it was a lot better for the kids, so.
Now, depending on which version you believe, she was mad at you because what you were doing on your phone, or you were mad at her for what she was doing on her phone. And as your lawyer said, alcohol was a factor here. I don't know that she ever sent in her victim input stuff. So you guys are gonna have to figure it out. You got two small children, you didn't get married, so she has paramount parental rights. I don't know what her position is regarding allowing you back into the home. Normally, when I do a probation, I lift the no contact provision. So let's do the malicious destruction of property case first. That's the November 13th case. The domestic violence charge in that case was dismissed. You spent 4 days in jail in that case before you posted the bond. There's a $75 crime victims' rights fee and a $50 state minimum fee and a $55 fine, which equals $180. You posted a $2,000 10% bond. You posted $200. The court keeps 10% of a 10% bond, so there's $180 to apply to your fines and costs. I'll reserve on restitution. That probably isn't any. You fixed the door and your father's the property manager. But if there is, I can always amend the order and allow it. That takes care of this 13th matter. Now, the next one 10 days later. And obviously the prosecutor was quite concerned about this. There were bond conditions of no contact, which you violated. Who are Jason and Samantha Stainer?
Those are my parents.
All right. She stated Caleb was at her house when she got home, that he kept driving by, leaving and coming back. She kept asking Caleb to leave, but he would not do so, at which time she left. When she came back, Caleb was gone, but then he returned when he saw her vehicle back in the driveway. Caleb entered the residence through a front door, which does not lock, and came into her bedroom, grabbed her by the head using both hands and hit the back of her head on the bed frame multiple times. She had bumps on her head. According to Baldridge, Caleb held her down by her arms with her legs and punched her in the face using a closed fist. Baldridge stated that Caleb told her he would beat her ass. He would give her a reason to call the cops. Took the phone from her. I mean, that's bad. She had to run out and call for help. They arrested you like over at Bronson later that night. So there's no mention here about alcohol, except it should be noted for medical reasons. I asked Caleb on a 1 to 10 scale how drunk he was, and he said a 3. Caleb said she was drunk, but I just came from Baldridge and she did not note any signs of intoxication. And you came home. Anyway, alcohol was a factor, but you weren't even supposed to be there. She's got a 3-month-old child in the house. She doesn't have time to be out driving around. By the time they finally caught up with you at the jail, your blood alcohol was 240. So this case also includes a bunch of drunk driving, where you're driving around here in Branch County while you're drunk. You got 30 days sober. I guess that's a good start. If you're both drunk, I don't know who's taking care of these very young children. But you don't just get to that high of a blood alcohol level without building up a tolerance. For you, a 2.4 is a 3 on a scale of 1 to 10. I hate to think what you're like when you get to a 10. Of course, when you're drunk, you're not the best judge of how drunk you are. On the illegal entry charge from the second incident, or 10 days credit, 10 days. Concur with a domestic violence case. 0 fine and costs. I had really hoped to hear from her. I'm not sure what she feels about the no contact provision or how she feels about this. She also bit you. I mean, it's just bad. As Ms. Stoll said, you guys are old enough to know better than this.
I have advised my client that through my work in the family courts, this is the kind of situation that leads to foster care.
Yes,
So
it does.
I think that has also been made clear to him.
All right, on the domestic violence charge, what do I do? I don't like the fact that you were on a bond with no alcohol and no contact and no assaultive or threatening behavior. You went out and did exactly the things I told you not to do. And according to her, you punched her in the face. You were 3 times the legal limit to drive a car. Plus you're driving a car around drunk. One option is just give you 90 days in jail and see how you like that. It makes you lose your job. This deserves 90 days or more in jail. We set a very high bond, $30,000 cash or surety, was reduced from a felony to a misdemeanor, and then the bond was reduced accordingly. But I think you posted a $30,000 bond. Did you post a bond through a bonding company?
Yes, sir.
You had to put up $3,000?
$1,800.
What's that?
$1,800.
And that's all money away from your family.
I just made my first payment on the bond today.
Say that?
I said I have to make my first payment on the bond today.
Prosecutor's asking for 4 months probation. I think that's appropriate. You can be discharged at the end of 12. It's to be determined whether you're eligible for a deferral. I'm going to send you to the DV class, the full class. No drugs and no alcohol, no assaultive behavior, no marijuana. Do you use marijuana?
I do not.
I'm going to sentence you to 90 days in jail. Credit 10. Of the 90 days, 80 are deferred. It won't take much for me to pull the pin and just give you the balance of the jail. So I want you to comply with the terms of this probation. Fines are 0. You got enough to pay. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee, $960 probation oversight fee, which could be cut in half if you do it in 1 year. You got to pay for the class. The deferral is to be determined. I can't do a deferral in a domestic violence class without the prosecutor's, in a domestic violence case, without the prosecutor's consent. And we'll put you in the program and see how you do if you complete the domestic violence class successfully, and otherwise complete the probation. I'm sure the prosecutor would agree to a deferral. If you don't, then this will show on your permanent record. I'm gonna leave the no contact provision in place until further order. I have two options, lift it and have her request me to put it back, or leave it in place and have her request me to lift it. But I don't want to lift it without input from the complainant. No contact remains in effect until further order of court. You are communicating between intermediaries, and that's good. You guys have done about as best as you could through the holidays. But she's never returned any contact from the prosecutor's office. And I would ask whoever your intermediaries are to direct her to contact the victim advocates at the prosecutor's office or the probation department, and I can determine what to do with this. If you don't have any, or you're not married, and you don't have a custody or support order, who's paying all the bills?
Just when I have the kids, it's on me, that type of deal.
Well, who's paying the electric bill, the gas bill at the address?
I'm sure what she's doing. Last I knew, she was trying to move out of there. So, I do know that she's a couple months behind on the rent. Because when I was there, I took care of a lot of that.
Well, so now that you're not there, you don't have to pay rent anymore. Well, that's a good deal.
I paid my dad. Correct.
And your two kids are a half a step from homeless. So you don't know who's paying the propane bill or the electric bill?
I do. I would assume she is.
Well, what does she have for income?
She is a server at Judd's Barbecue in Angola.
Who watches the kids while she's at work?
Right now, with all this going on, I'm off during the week because my work didn't want to put me on all of my hours. My mom takes them quite a bit, and my dad also watches them.
She got a 4-month-old baby and she's working as a server and 45 minutes away?
Yeah, she works 5 or 6 days a week. She makes okay money. But like I said, I wouldn't know for sure what her financial situation is exactly.
What to do? We need a probation here. Yeah, it's like I'm dealing with two 18-year-olds. All right, I'd like to hear from her. All right, you're on probation on the domestic violence charge. No drugs, no alcohol. Test as directed. No assaultive or threatening behavior. They could also use some substance abuse counseling. I'd like you to stay plugged into AA. No contact remains in effect unless I hear from her, in which case I can lift it. At least you can talk to each other. Whether you're going to move in together, I don't know, but and you're lucky you didn't hit a tree or something in the meantime. This does not affect your driving privileges, even though you were driving around 3 times drunk. I want you to go down to the probation department and get plugged into that. I will say your attitude has been pretty good. As Ross said at the time of the plea back in December, you're like, okay, I owned it. I accept responsibility. I don't like you punching her in the face. I don't like you going over there in direct violation of my orders. But let's see if we can make something out of nothing here. Otherwise, you'll end up in jail for a while, 80 days. All right, you go down to probation. I will reserve on the deferral question.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Mr. Cole.
All right, another quality human being has shown himself here on TCF Live. We started the day on the pre-show talking about people behaving badly when children are involved, and it's kind of turned into a little bit of a theme, I suppose, today. But that's not a hard theme to have. We see a lot of that. There's always some kids suffering for what adults do. We need to figure that stuff out. Anyways, let's go back to Judge Simpson's court. Young Reagan seems to be present.
I was told that she got out of custody.
She is not in custody.
Not in custody.
Good start for the new year. Happy New Year.
Strike one. But unfortunately, I did try and get in touch with her. I'm not sure if she just got out of custody. I do know people have difficulties with their phones and things like that when they get out of custody. So respectfully, just asking for a second chance.
You want a second chance?
Second chance.
Okay. No. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000 to give a 10% privilege on that will issue immediately.
All right, thank you.
All right.
You know, have a great one.
That's it for you?
Today.
Okay.
Don't worry, tomorrow.
Maybe that'd be a different day, yeah. All right, thank you, sir. Court calls the case, People versus Wesley Brand.
What are you already cook the people?
And Assistant Public Defender Natalie Pate, on behalf of Mr. Brand, who is approaching. Please state your name for the record, sir.
Wesley Brand.
Thank you, Your Honor. I have had the opportunity to discuss the case and discovery and everything with Mr. Brandt. We are asking to set up for final settlement conference.
Final settlement.
Yes, Your Honor.
Jury final settlement conference will be set February 6, 2026 at 9 a.m. Jury selection will be set February 9th, 2026 at 8:30. Both of those proceedings are in person. Bond will continue. Okay.
Thank you, Your Honor.
Let's call the case of the People versus Jocelyn Karuna.
What are you already cook the people?
Good morning, Assistant Public Defender Warren here on behalf of Ms. Corona. Ms. Corona, state your name for the record, please.
Sorry. Good morning. My name is Jocelyn Caruana.
Caruana. All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
The plea form indicates that the defendant would be pleading guilty to an added count 2 of operating while visibly impaired, the 93-day offense. Upon our successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of it. Is that correct?
That's correct.
That is correct.
Ma'am, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right. State your name again for the record, please.
My name is Jocelyn Caruana.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could also order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. Do you understand that, ma'am?
I understand, Your Honor.
And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
All right, and to that charge, how do you plead?
I plead guilty, Your Honor.
All right, thank you. Now you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
All right. You had or caused to have signed an advice of rights form. Is that correct?
Correct.
Do you have any questions regarding any of those rights?
I do not, Your Honor.
You understand that you're waiving or giving up those rights that are contained on that form, particularly the rights in paragraph 5, which are your trial rights.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened or coerced you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will
Yes, Your Honor.
because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
April 5th, 2025, at the location of South State Street near East Michigan Avenue in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Correct, yes.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What did you have and how much?
So I drank a shot of tequila and a shot of aloe. Shot was what it was called. I'm not really sure what it is.
Okay, were you stopped by the police or was there an accident?
It was an accident.
What happened?
So on April 5th at approximately 12:30, I was leaving Lucas substation. I had consumed the 2 shots that we discussed, and I failed to stop at a red light at the street of State Street and East Michigan Avenue and hit another vehicle.
Okay, did the police arrive?
Yes, Your Honor.
All right, were you ultimately arrested?
Yes, Your Honor.
And were you ultimately taken to the hospital for a blood draw?
Yes, I was taken to the station first and then taken to the hospital.
For a blood draw, correct?
Correct.
And were the results of that blood draw 0.117?
Yes, Your Honor, correct.
Okay, do you have any reason to dispute those blood test results?
No, Your Honor. I believe last trial or the pre-trial, we discussed the difference between the BAC on a ticket versus the blood draw.
Okay, but you don't have a reason to dispute those blood test results of a 0.117, do you?
No, I did not.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Ma'am, I do have to advise you that if I accept your plea and you commit misconduct between the time that I accept your plea and the time of sentencing, that first of all, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation or to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
At 9 a.m.
February 11, 2026, 9 a.m. Bond with its conditions will continue. Do I have probation intake? I do. All right. And ma'am, I'll ask you to wait on the line. We're going to put you into a breakout room with my probation department so we can begin the sentencing process. Okay?
Thank you. Thank you, Your Honor. Happy New Year.
Thank you. And to you. Court does call the cases of the people versus Devontae Connor Belcher.
When Your Honor, Raymond Cook for the people.
5 cases.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Connor Belcher for one of those cases.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Connor Belcher in the other 4 cases.
Sir, can you please state your name?
Devontae Connor Belcher.
Thank you, sir. All right, what are we doing?
Your Honor, we're here for a series of cases, and we're going to be working to get Mr. Connor Belcher into like a recovery court or a drug court program.
All right.
And so we're hoping for an adjournment for a couple of weeks to get that process started.
Okay, do you think you can get, is he held on anything else other than these? Or?
There's a PCC tomorrow for retail fraud in the 1st degree before, Your Honor.
Okay, so he's held, okay. So how much time are you going to need on?
2 weeks to get started. February 4th date is fine as well, Your Honor.
And
That is all correct,
Agreed.
Your Honor. Yes.
all right, I'll adjourn all of these matters into February 4th, 2026, 9 a.m. Bond will continue. Thank you.
There you go.
Thank you. Court calls the cases of the people versus Christopher Dale Chambers.
Morning, Your Honor, Raymond Cook for the people.
I have two cases. They're arraignments without. Dale Chambers. Christopher Dale Chambers. No response. I'll issue orders to show cause on both of these matters for the defendant's failure to appear. Court does call the case People versus Brandon Davis.
Morning, Your Honor, Raymond Cook for the people.
This is Public Defender Natalie Pate, on behalf of the
You have it. Brandon Davis. Might be Motorola. Brandon Davis.
Yes, I'm here.
All right, what's your name?
Brandon Hezekiah Davis.
Thank you.
Thank you, Your Honor. I'm requesting an adjournment. Mr. Davis' license is still suspended, so I have to use more time for him to work on that.
How close is he to?
I don't think it was overly close. I don't have his drive record. But I think he's paying off some stuff in the time. It's working, is my understanding. Reflection.
Yeah.
So a date after the 4th.
February.
During the matter, you're gonna have to figure out what you're gonna do on this, because he's got to show some significant progress. I'll adjourn it to February 18th, 2026, 9 a.m. Bond continue. Court calls the cases of the People versus Matthew Wallace.
Conrad Solar on behalf of Peaceful Township.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Wallace. Mr. Wallace, state your name for the record, please.
Matthew Wallace. Thank you, sir.
Your Honor, Mr. Wallace has a couple of cases in circuit court that we're kind of waiting to be resolved. His next court date there is not until February 4th. So I'm asking for an adjournment of these cases. Those are kind of driving the bus here.
They're okay.
I have no objection to a date before then to see if something moves. But he's not. His next pre-trial is not until February.
The pre-trials on February 4th aren't until the afternoon.
Right.
Right, so he'd be, if I set it for the 4th.
He'd be here.
Call before it.
Yeah.
Okay. And those cases are holding him, really?
Yes.
Yeah.
Yeah.
And there's another felony up for probable conference next week.
That
A
is
new
true.
felony.
It was a new case, older date of offense, but
A new case that's coming before me for PCC.
yeah, I think it's
Next week.
scheduled, not this Thursday, but
The 15th, the 15th.
15.
January
Yeah.
15th, yeah.
and I think that's obviously gonna probably follow the,
Follow with the, okay.
Yeah.
All right, so let's do this. I'll adjourn it to then February 18th, which will be my next date after the 4th, 2026 at 9. I'll adjourn both of these to that date. If something, because I think I have bonds on these cases just so that he's getting credit. But if something occurs, let us know. If he's going to be released on everything except these cases, let us know so that we can.
I do think he has released this, I failed to mention this, he has released the treatments on those other cases. And
On
the everything else, there's one coming to Your Honor today for these cases as well. Mr. Cook and I discussed it prior to the hearing. I think these may be the last ones that needed one. So he may be released to treatment before then as well. I forgot about that piece.
Got it. Okay, so, okay. I'll sign those orders. They're coming on these two.
Right.
Got it. Okay, that makes sense.
Thank you.
Thank you.
Yes.
Court does call the case of the people versus Comaria Davis.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Davis.
She's there, yeah.
Where is she? Oh, yeah. Ms. Davis?
Yes, my name is Comaria Davis.
All right, I'll need a camera on you, please. She just muted, and I need your camera turned on, ma'am.
Ms. Davis, there should be a little camera with a line through it. You gotta click that.
If people don't know how to work Zoom, we're gonna stop letting them appear that way.
Ms. Davis, is there a problem?
You're muted, Ms. Davis. Ms. Davis, unmute. She is now gone. I will call her up at the end if she's not here. Unless you'll bench warrant, hold it to the end of the day. She'll need to present herself in person to the court. Court does call the case of people versus Michelle Campbell.
When you're on ready.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Campbell. Ms. Campbell, state your name for the record, please.
Michelle Campbell.
I have before me a plea form that indicates that the defendant would be.
Ellie. Hang tight, folks. Ellie just hit a button. Let's get. Okay, there we go. Sorry, guys.
Upon her successful plea to that charge, the other case, which is up for today, the case ending in 0533 would be dismissed. That's the court's understanding of the.
Yes.
That is accurate, Your Honor. I believe there was some indication that restitution be reserved for dismissed counts.
Okay, so what should have been put on here is she's going to pay restitution on all counts. Is there an agreement to that?
There is, Your Honor.
Can I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give the whole truth and nothing but the truth, so help you God?
Yes.
State your name, please.
Michelle Campbell.
All right, Ms. Campbell, it's this court's understanding that you are going to be pleading no contest to the charge of retail fraud in the second degree. Is that correct? That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Do you understand that?
Yes.
And that the fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine.
Yes.
You understand all that? Do you understand what a no contest plea is?
Not really, Your Honor.
Okay.
This is my first time.
No, it's okay. But you don't understand what a no contest plea is?
Not really.
Okay.
I would like to understand.
Have you talked to your attorney about that? Pardon?
A little bit yesterday.
A little bit yesterday, but you still need more time to.
I would like to.
Okay, let's listen. If I pass this case and the attorney can get back and talk to you, you think you'll be able to have a conversation to see if you understand what you're doing?
Yes.
Okay, so what I'm gonna do is I'll hold the files, we'll pass it. And when you get a break, we'll go back and talk to her about what she's actually doing.
Sounds
Okay?
good. Thank you, Your Honor.
Thank you. Court calls the case, people versus, is it Elka's Michael Russell?
Morning, Your Honor.
Yes, Your Honor.
Hold on a second. Why? All right, everybody thinks I'm mispronouncing names. That, the way this reads is he has the longest first name known to mankind. And then I'm looking at the screen and it's just Mike. Do you see it?
No, yes, Your Honor, I do see it, and it looks like
That is all wrong.
they corrected it, but didn't give you a new sticker. But I got you. I got you.
See, and everybody was gonna blame me. I want it clear on the record, this is not my fault. And Mr. Elkins, I apologize for them doing this to you and me.
That's no problem, Your Honor. I've got two middle names, so it's been an interesting time with that.
Okay. Court does call the case. Other people versus Michael Elkins.
This is Public Defender Natalie Pate on behalf of Mr. Elkins. Please state your name for the court.
Michael Elkins.
See, told you. All right, what are we doing?
We're actually requesting as well, frankly, lengthiest adjournment the court would allow. It does have some issues that he's thinking about Indiana DMV. A lot of it has to do with some payments he needs to be making down there. That being said.
Indiana.
Yeah. Great place.
Is it?
I don't know.
They got a good football team. That's all I know about now. Got a good football team, but that's like a blind squirrel finding a nut. It just happened. So how much time?
As long as the court would give us, to be honest with you. We're going to try to see if we can make progress within the amount of time you would give us for an adjournment. And if not, I would then be talking to Mr. Cook about a potential.
About something. Okay. Why don't I adjourn this out to February 18th, 2026, 9 a.m. And bond will continue. Okay, Mr. Elkins?
Thank you, Your Honor.
All right, thank you.
All right, bonds are continuing to continue over in Washtenaw County. Hello, Ellie. Let's try not to push buttons this time. Let's go. We'll stay in Michigan, but let's go back and see what's going on now with Judge McNally.
Good morning to you. I don't think I ever signed the summons here, so I'm signing it today. All right. So what have I got here?
This is a fraud charge.
Does he have any criminal history?
He does not have any criminal history, Judge.
Okay, so for purposes of arraignment, does he stay in mute, wait for
Yes,
formal reading?
we do, Judge.
I'll enter a not guilty plea, and then, as I understand it, he's going to plead guilty. There's going to be restitution amount of $482.36, and the agreement is that the prosecutor will take this, or ask the court to take it under 771.1 for a period of 12 to 18 months. True?
That's correct, Judge.
All right. Is that what you want to do, sir?
Yes.
If you plead guilty here, possible penalties on this are up to 500 fines. 93 days jail. Costs are all of those. I'll place you on probation at some point, set terms and conditions. We do have to notify the victim. They still have the right to appear. If you're compliant during the period of probation that I set, then at the end of that period of time, the case will be dismissed. Can't really do it for 18 months. You know, the maximum really on a 771 is 12.
We just wanted to exhibit good faith, Judge, and that's why we.
No, I understand, but that's good. That's fine. I got it. So do you understand all that?
Yes, we do.
And did you sign
Judge, I explained the advice of rights, but he did not sign.
Yeah, I need you guys to have them sign this if you would, please. All right. All right. All right. Are you, satisfied with everything, Mr.
I am satisfied, Judge. We'll also rely upon the police report.
All right.
Basis. Thank you, sir.
All right. Do you understand everything on those advisory rights? I can't hear.
Yes, sir.
Did you sign it, read it, and understand it?
Yes.
If you plead guilty, you will be giving up all those rights, and we are not going to have a trial of any kind. You understand that?
Yes.
All right. Any questions before I ask you how you plead?
Yeah, Your Honor.
To the charge of retail fraud, how do you plead? Between, was this over a period of dates?
It was over a period of dates, Judge, and he confirmed what happened in the report, so we could rely on that.
So between May 1 of 25
in October, I believe, Judge, or a number of incidents in that report.
and October 27 of 25, were you at the all these? I gotta have you keep your voice in.
Yes, sir.
Did you take property offered for sale without paying for it?
Yes, sir.
Was the store open to the public?
Yes, sir.
Did you walk past the register with the intent to steal the property?
Yes, sir.
And was the property at least valued at $482.36?
$82. Yes, sir.
Anybody force you to plead guilty?
No.
And that was at Aldi's in Woodhaven at 20078 West Road, correct? Are you on probation or parole?
No, Your Honor.
Anybody in the world force you to plead guilty?
Courtroom.
Okay, I'm going to accept your plea. I find it to be an accurate plea made voluntarily and understandingly. The plea is accepted. I'll take it under section 771.1. I'm going to give you a $1,500 personal bond, and here are your bond conditions. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with Gregory Mulford or employees of the Woodhaven Aldi. You cannot write, phone, see, text, email them, communicate with them, or have anybody else do any of those things for you on your behalf. Nor can you have any contact with prosecution witnesses except through your lawyer. You're not to enter the property address of 20078 Weston Woodhaven. You are required to go to Woodhaven Police Department and be photographed by January 7th at noon. Was there any drugs involved?
None, Judge. There's no drugs or alcohol involved. This is.
Okay. Pre-sentence report and sentence date. We're going to give you a sentence date. You're going to go down the hall, pick up that date, the notice. You're going to get a copy of the order for prints. You're going to get a copy of the bond sheet. And then you're going over to probation where you'll be interviewed. And then you're going over to Woodhaven by noon today to get photographed and fingerprinted. Do you understand all that?
Yes, Your Honor.
Okay. So what do you have for a sentence date for me?
It'll be February 4th at 8:30.
Is that good with you?
Judge, that would be fine.
He doesn't want to do the court to school, does he?
No, Judge, this has been a very.
Okay, good enough. February 4th at 8:30.
Thank you.
All right, you understand everything?
Yes, Your Honor.
Does he work?
He does work right now, right now he's on a disability, short-term disability, Judge.
Okay. All right, so we'll see you back here. I wish you well. Any questions?
No questions, Judge. Thank you again.
Have a good day, Mr. President. Thank you. Eon Michael Evans. 24W836404.
Ian Adams.
Is he in custody?
Yes. Okay.
I don't understand these guys. All you gotta do is come talk to us. All right, detective, your name?
Detective Davis, Woodhaven Police Department.
Mr. Evans, your name?
Ian Evans.
Your appearance?
I would expect Ian Adams.
What is he gonna do?
Judge, he works for 4 and gets paid Friday and can have this paid by Monday, but he will plead guilty to felony.
Hang on, look at me, Mr. Williams. You understand what your lawyer said? Hello? Talk to me, not to him. He's the police officer. I'm the judge. Come on up here. Are we having a problem with the volume?
A little bit. I didn't tell you were talking to me. My fault, sir.
All right, that's all right. Can you hear me now?
Yeah, I can hear you.
Your lawyer tells me you're going to plead guilty. If you plead guilty to this failure to pay $285, you could get 29 days. You can satisfy that in full by serving the 29 days, so you'll be out by February the 4th or 5th, or you can pay it all, or you can serve some time and pay the balance. You get $10 credit for each day served. Do you understand that?
Right.
I can't. You understand that?
Yep.
You're presumed innocent. They have to prove you guilty by preponderance of the evidence. You have the right to question their witnesses. Bring in your own. Use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we are not going to have a trial of any kind. You understand that?
Yes, sir.
To the charge you failed to pay $285, how do you plead?
Plead guilty.
You failed to pay?
His balance is actually $320 now.
Oh, $320 because of warrant fees, because he doesn't show up. To the charge you failed to pay $320, how do you plead?
Guilty.
So you could get 32 days. Do you understand that?
I do, sir.
You failed to pay?
I cannot pay right now. I'm sorry.
Did you fail to pay? You got a problem.
I did fail to pay.
Anybody force you to plead guilty?
Nobody forced me to plead guilty.
How old are you?
How old am I? 22. Just turned 22.
You work at Ford Motor Company?
A little over a year now.
Where at? Which plant?
Down in Monroe, the packaging plant.
How much do you make there?
I just now make over like $25 an hour.
You married?
No.
Kids?
I have a kid on the way in April.
You're making $25 an hour and you haven't paid your fines? You got a big problem here. You better call somebody.
Yeah, it was.
You don't think I'm going to let you walk out of here today, do you? You show disrespect like this, you don't pay.
I know.
Hang on. If you told me you were making $8 an hour and you had 4 kids and somehow, some way you didn't have the time to come in here, I might understand it. You should have come in and talked to us. You didn't show up in March. You blew this off. Yeah. Did you let him make Detective your name?
Detective Kyle Davis.
Did you let him make calls?
He did get a phone call with his mother, I believe, hours ago.
You better get your mother to bring you the money.
Yeah, I already, it's all my money, and I pay rent and stuff on my own, so I don't get paid. I don't get paid until Friday.
Rent to who?
My rent. I pay for my own house and stuff, so I
you own a, listen, do you rent a house?
I do.
Where's the house?
It's over there in Taylor.
How much you pay per month?
Just about $1,500, a little bit more. Like I wish I had the money. Like, I would pay it right now if I could. Like I said,
It's not that you don't have the money. That's not the issue. The issue is you should have shown up for your show calls and said,
here's the thing, though.
Listen, you're interrupting. Judges don't like it when you interrupt. You should have just come in here back in March and said, Judge, listen, I'm having some hard time. I pay $1,500 a month. I don't have the money. Can I have an extension? In which case I would have said yes. And if you did that, you're interrupting me again. I thought I said not to interrupt me. If you did that 42 times, I still would have let you go on. Do you understand?
Yes, sir. I understand. Can I add something, Your Honor?
Can you have what?
Can I add something? I haven't the reason why I haven't had no vehicle though. So ever since
Wait a minute, I didn't hear that. I didn't hear that. You what?
I haven't since I got that accident though. I never even knew that I never had no vehicle to get that ticket or warrant handled. So I never even knew that it became a warrant until I had my new vehicle set. So it's kind of I didn't avoid it. I just could never make my way down to Woodhaven or anything like that to
Hey, that sound like you live in Iron Mountain, young man. You drove by here every day. Where's the plant you work at?
I technically don't drive there. My mom, I drive
Where's
my
the
mom.
plant you work at?
Monroe.
Where's Taylor? Is it north of here or south of here?
It is, that's north from Monroe.
Where is Monroe from here? Is it south of here or north of here?
South.
You drive by here, whether you're driving whether you're taking a helicopter ride, a boat ride, you're taking a bicycle, somebody's driving you. You come by here every single day. I-75 you would take to Monroe, and there's a Woodhaven exit on I-70 off of I-75.
Yeah,
Make it sound like this was an impossible task. We didn't ask you to go to the moon.
Yeah, I'm sorry. It was real.
It's not, you don't have to apologize to me. You're going to be the one that's going to end up with the consequences here.
I know. It's just things. Like I said, when I got that ticket, I didn't. I lost my car. I was in the middle of moving, and I never even really thought of it. And then I got a car back, and then the car blew up on me, and then I had to get a new car. It's just been it's not even like I don't even drive to work. To be honest with you, my mom drives me to work. So, I carpool with her. We work together. So, it's not that I purposely avoided or, it's just I just never even really had thought of it. I ended up moving. I never got an email or text that the ticket became a warrant or anything like that. So, and
hang on, slow down. Detective, where was he picked up?
Southgate.
What was he doing in Southgate?
It was a traffic stop. The officer indicated that the high beams were on, so he pulled him over because the high beams and windows.
I thought you just told me you don't drive. Did you just tell me? Hang on.
I said I don't drive.
Hang on.
I don't go down past Woodhaven though. I go to reviews of the gym and that's it.
You drive to Monroe for work, right? Somebody drives. You don't take a helicopter, do you?
My mom, yeah, I drive with my mom down there, but I ride back here up to Taylor after work, and then I go to the gym. The gym.
The more we're having this conversation, the more I think you need to go to jail.
Okay.
These guys. How much do you get paid on Friday?
They should get paid around. It's a holiday check. I should be getting paid pretty good money.
I didn't ask you that. Can you pay this all on Friday, or do you need more time?
I can pay it all on Friday, sir.
Are you sure?
100%.
I will give you more time if you need more time, but you can't do this. You should learn that this should be a lesson, because really you should go to jail today. Are you sure you can pay all of this on Friday?
The 300 and what is it, $20 now? I can give you even more than that.
I don't want more than that. You pay $320 by January the 9th. Actually, I'll give you credit. When was he picked up? This morning or yesterday?
This morning at 2:20 in the morning.
Well, he spent some time in jail. You pay $310 by January the 9th. Any balance waived? There is no balance because I'm giving you $10 credit for the last few hours. Come on. Don't get in the habit of a lot of these other guys, will you? You're going to just make your life miserable.
I know.
Enough without doing that. Judges are not unreasonable. You go talk to them. Judge, I don't have the money. Nobody's going to give you a hard time as long as you go in there and are up front. You're not brought in handcuffs. Best of luck. Thanks, Detective. Jonathan Glenn Compton.
I'm sorry, Judge, I missed the date it cut out that you gave him.
He's going to pay by the 9th, Friday.
Okay, perfect. Thank you.
Thanks. Jonathan Glenn Compton.
So I continue to just be disgusted by people who have loads of excuses and zero responsibility, and the common sense is a negative number. But I'm not going to hijack the show to go off on a rant, but I will hijack the pre-show. So I think I know what we're going to be talking about tomorrow. So channel members, gear up for that. If you're not a channel member, please do consider joining and get access to the pre-show, which is a half an hour before this show every day. Okie dokie, let's go back to Louisiana, see what kind of accountability is going on there.
Time is 9:18 in the morning. The date is 1/7/26. To my right is Jerry Ledoux. To my left is Chuck Tillis. My name is Steve Prater. We're talking to you, Mr. Demetrius Coleman. Is that correct?
Yes, sir.
And you're at the Bossier Parish Maximum Security Facility. Are there any deputies in the room with you?
Yes, sir. Deputy Danford with Bossier Parish.
Okay, well, hello. Good to see you, and we appreciate you hosting us this morning.
Yes,
Okay, Mr. Coleman, what is your DOC number?
381-833.
Okay, and do you have a waiver in front of you that you signed for this hearing?
No, sir.
Did you sign a waiver to have the hearing today?
Yes, they just told me I had to have a hearing. That's what the new thing was.
Okay, we're gonna try to find the waiver. Okay, do you see that in front of you right now?
Yes, sir.
Did you sign that?
Yes, sir.
Is all of that true? And I see it's got, okay, is everything okay? Are you, other than suffering from anxiety, are you stable and willing
Yes,
to
sir.
have a hearing?
Yes, sir.
Okay, and you're okay with having this hearing, correct?
Yes, sir.
Okay, all right, well, your case has been signed to Mr. Chuck Tillis, who's on my left, and he's gonna ask you some questions, and then the board, the rest of us will ask questions if we have any. Then we'll make our determination whether you should be revoked or not, okay?
Yes, sir.
Morning, Mr. Coleman. How are you?
I'm doing fine.
Good. You have two violations that you violated, and rule number 3, you move from, and you can answer these guilty or guilty with a not guilty and not guilty with a statement if you would like to. And we'll go over the two and then come back and talk about them. You moved from the address recorded within Baton Rouge to a new address in Shreveport without notifying your parole officer. How do you plead?
Not guilty.
With a statement?
Yes, sir.
Rule number 4, you were arrested on 9/28/2025 by the Bossier Parish, Bossier City Police Department for domestic abuse battery. How do you plead?
Guilty with a statement.
Guilty with a statement. Okay, let's go with rule number 3. You said you were not guilty, and what happened?
Like I was trying to find some work now and I couldn't find a work, so I like go and work at the Two Guys Moving for like a week or so, and then I come back, because my little daughter was kind of having trouble, and I tried to get the parole officer. I was asking about jobs and stuff, and I go for a couple of days and I come back because he owned the Two Guys Moving down there, but I didn't move. I still stayed at my residence in Baton Rouge.
Did you notify your parole officer what you were doing?
No, sir.
Okay, so that's the reason why, you have to notify them. You understand?
Yeah.
Okay. Now, what about the abuse battery?
I was down there and I was on my way back to Baton Rouge and I was trying to get my clothing from this friend house that I was, staying at. And she wouldn't give it to, she like give me half my stuff. So I called the police and it took me forever to get the woman that want to send the police out there because I did the right thing. I got in front, stayed far from my house, got in the street. And I'm started telling the people, I need the police, I need the police. They started trying to talk to me. Before I know her and her daughter came out the house cussing at me. And I was like, they came just so fast. I'm like, man, get back. I swung my hand like this. It accident barely touched her lip and blood, and I ended up going to jail. So I guess I'm guilty like that, but I did nothing I was trying to do. I don't want to call the police, and I'm like telling the police, talk to the operator, because I was way far from their house, and they just came. It wasn't no accident. Like it was just like, man, get on back. While I was talking to the police, and I just barely asked her, and my fingernail hit her lip. Got a domestic. I pled guilty to it though.
Yeah. See, any of my colleagues have any questions?
No.
Jerry?
No.
Okay. Well, I'm ready to vote.
Okay.
Mr. Coleman, you just stated you wanted to do the right thing, and on rule number 4, and on rule number 3, you knew better and you didn't do the right thing. So my vote today is going to be to revoke for rule 3 and 4.
I concur with my colleague, violation of your conditions of parole.
And I concur also with violation of conditions 3 and 4 of your parole agreement. Therefore, as of 9:24 this morning, your parole has been revoked.
And there you go. Accountability forced upon him. At least it's getting done one way or the other. Let's go back up to Michigan, but let's see what's going on with Judge Mom.
Appearance for the people, please.
Good morning, Your Honor. Captain Busniak, P85417 for the people.
Thank you.
Corey Westmoreland, Paragon.
Thank you. And sir, your name for the record, please. Okay. And so the court had counsel in chambers because the court's very familiar with Mr. Jaguna and his family, given that Mr. Jaguna was just sentenced on another matter 1 week prior to his arrest in this matter. And the court expressed some concerns, given the entirety that this court, well, the information this court has based on its interactions with the family and the concerns that this court has for the safety of all involved in the family. And so I understand that the people are moving to dismiss, and that's because Anthony Jaguna does not want to proceed. Is that correct?
That is correct, Your Honor.
Good. Mr. Anthony Jaguna, please step forward. Please keep your hands out of your pockets, and please state and spell your first and last names for the record, please.
Anthony Jaguna, ANTHONYNJUGUNA.
Thank you. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. All right, and sir, you have spoken with the prosecuting attorney, correct?
Yes.
And you do not want to proceed in this matter?
Yes, sir.
And why is that?
Whatever was transpired was not what it was made out to be. And I heard about what all actually happened. It was nothing physical, it was verbal, and it was based on what I was told. I guess whatever the call my mom got. It didn't.
What was based on what you were told? I'm confused.
Oh, sorry, let me explain. The day after, we were told that he was basically going to be held, and based on the fact that we didn't pursue anything further, he would be let out the day after, and that's not what occurred.
Okay, no, I'm not looking at that, sir.
Okay.
The date of the incident.
Yes.
That required the police department to respond.
Yes.
Okay. So there was an issue that occurred at that time, correct?
Yes.
Okay. So you don't want to proceed with that issue?
No.
Why is that?
I didn't call the police, Your Honor. There was, whatever occurred was strictly between us, and it was nothing physical. It wasn't escalated to anything further. I was not in danger myself, although it was a verbal minor altercation. It was nothing that put me in danger or my family in danger, or nothing that I think deserves this level of punishment.
Was your dad sleeping in his car before this incident occurred?
Yes.
Was he sleeping in his car? Or was he passed out in the car?
I guess you could say passed out, yeah.
Okay. And so you apparently were frustrated, correct?
Yes.
And so you exited the house to address your frustration.
Yes.
And then what ensued is why the police were called. Do you know who called the police?
My dad.
Okay. So have you had contact with your dad since December 14th?
No.
Is anybody promising you anything, threatening you, or coercing you in any way for you to dismiss these, to not want to proceed?
No.
Do you feel safe at home?
Yes.
Do you feel safe at home when your dad's there? Mr. Jaguna, I can't see you because you're behind Anthony. Let me just be very clear. I know that Ms. Jaguna is also in the courtroom. You all need to get to counseling together. Whatever your anger issues are with each other, you need to work through it. Please stop chewing gum. There's a tissue underneath the podium, sir. you all need to get into counseling. Because the police department, the court, we are not your therapist. We are not here to resolve all of your issues. You can only do that within your home. So you need to really get on that ASAP. The court will grant the people's motion to dismiss. This is dismissed without prejudice. Is that accurate, counsel?
Yes, Your Honor.
Mr. Jaguna, this means that those bond conditions are now terminated. And so I believe that you had a tether, correct? I'm sorry? So you'll have to go over to probation and they will give you information about getting that removed. And then just confirm all of your contact information. So, or actually Miss Jaguna can go to the window, make sure that they have all of her contact information, and then a bond refund check will be mailed. You won't receive that right now. We typically do those once a month. Good luck to you all. And I think you're set to report on your other matter this weekend, sir?
Yes, ma'am.
Okay.
I had one quick question to you.
What's that?
On the this week, I get off on Monday. I don't remember Monday morning, right?
You should be released Monday morning about 12:01 a.m. so that you can still make work on Monday. That's why I structured the sentence as I did, sir, so that you would still be able to retain your employment.
Thank you.
Good luck to you all. Have a good day. There's no talking in court, ladies. We're on the record in the matter of the City of Wyandotte versus Terry Plumley, 251753. Is that one kind of?
Yes.
Okay. Is that yours? Mr. Gopal. Would you mind wrangling him in? Thank you. Good morning, sir. We're just waiting for your attorney to jump in.
Yes, ma'am. Thank you. Good morning.
Good morning, Mr. Gopal. Happy New Year.
Thank you, Your Honor. Good morning.
Thank you. Okay. And so this is Mr. Plumley.
I'm sorry. Thank you. John Goldcorp, P. 307, on behalf.
Thank you. Mr. Plumley, your name for the record, please.
Harry Sean Plumley.
Okay. Today's date scheduled for the pretrial. Your client was arraigned while he was in custody on December 23rd on fraudulent schemes or disguises. In counsel, did you have an opportunity to review this matter with the prosecuting attorney?
Yes, I have, Your Honor. I did speak with Mr. Plumley. I also spoke with the prosecuting attorney regarding the circumstances of this matter. It's my understanding that Mr. Plumley would plead guilty to the charge of fraudulent schemes, and there is a recommendation of time served in this particular matter. Plumley has been incarcerated for approximately 15 days, and I believe that under the circumstances of this fraudulent schemes charge, that would be appropriate under these circumstances. I have advised him of his constitutional rights. He understands those rights, and will he will waive rights, Sean.
Okay, Mr. Plumley, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
All right. And sir, you heard the plea that was placed in the record, correct?
Yes, ma'am, I did.
And as to the charge of fraudulent schemes, how do you plead?
Guilty.
You understand your rights that you've gone over with your attorney, correct?
Yes, ma'am, I have. Yes, Your Honor.
And you understand by entering into a plea that you'll be waiving some of those rights.
Yes, ma'am, I do. I understand. Yes, Your Honor.
You also understand that by entering into a plea, the possible penalty as a result of that plea, whether in this court, any other court, or administrative agency.
Yes, I do understand. Yes, ma'am. Yes, Your Honor.
And you understand the recommendation from the prosecutor is time served, but that's only a recommendation, and I'm not required to follow that. Do you understand that?
I do understand that. Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am, I have not been. No,
Okay,
Your Honor.
counsel? All right, any immigration issues?
No, Your Honor.
Counsel, if you can please run your time.
Thank you. Mr. Plumley, back on on December 22nd of 2025, were you in the city of Wyandotte?
Yes, sir, I was.
And you were a passenger in a vehicle that was stopped for a traffic violation. Is that correct?
Yes, sir, I was.
And when you were speaking to the Wyandotte Police Department officers, they asked you for your name and you gave them your name. Is that correct?
Yes, sir.
What name did you give them?
I gave him the name that I go by, the name that I use daily. I just told him my name was Sean. I wasn't thinking that he didn't know that wasn't my name that I use, that I go by.
And in fact, Sean is your given middle name. Is that correct?
Yes, sir.
And you spelled it for them.
Yes, I did.
And they indicated, well, are you sure? And eventually you answered the name Terry. Is that correct?
Yes, sir, I did.
And Terry's your first name. Is that correct?
That's my first name. Yes, sir, it is.
Thank you. Also, and I want to bring to your attention, Your Honor, on the register of actions, it has a birth date of 6 of 85. His birthday is 6 of 75. Now, the other information that he gave him, it appears that they mixed that up as well. Only for those.
Who mixed that up? Your client or the police department?
Well, he insists he gave the address of the birthday of 75.
Well, it's possible that when we entered it in our system.
I understand.
Yeah, so I made that change.
He also has a different birthday on his tag in jail. So that's why he brought that to me as well.
Okay.
Okay, I just wanted to bring that.
Well, they had 2 birthdays for me. I'm sorry.
That's all. That's okay.
Tell me what you're wanted for out of Tennessee.
It's a probation violation,
And what are you on probation for out of the state of Tennessee, sir?
sexual exploitation.
And does your probation
Attempted.
officer know that, excuse me, does your probation officer know you've relocated to Michigan?
No, ma'am, he doesn't.
Well, that's a problem, sir.
I was going back to Tennessee. I run out of work up here and I was on my way back to Tennessee.
Interesting. What's going on with your matter out of the 25th District Court from River Rouge?
That I've gotten there was an incident that occurred and I was.
Yes, I know that, sir. That's why I'm asking what happened with that. Have you been arraigned? Do you have a?
No, we're still, I'm working with a detective named Eric on that matter still. And I was trying to work some things out with him that he requested that we hadn't really made it to yet.
Okay. So here's what this court's, there's no talking, ma'am. If I have to tell you again, you'll be out in the lobby, okay? So, sir, and counsel, here's what this court's going to do.
Yes, ma'am.
Do you need,
I'm fine. No,
are you sure?
I'm sure you are.
Okay. Given your warrant out of Tennessee and the fact that you have relocated out of Tennessee without permission from your probation officer,
yes, ma'am.
and that you have a pending matter in the 25th District Court, or pending
Yes, ma'am.
charges potentially, and now you have this matter, the court is going to issue, the court does not find that there's reasonable grounds to depart from MCL 769.5. The court's going to order 60 days jail. I'll give you credit for the 16 days that you've been in custody.
Yes, ma'am.
And I will waive your fines and costs.
Thank you, Your Honor.
Yes, ma'am. Thank you, Your Honor. And once again, I apologize to the courts and to the arresting officer. I didn't think that he didn't know my name, that I didn't go by Sean. I apologize for that.
All right, good luck to you, sir. Have a good
Thank
day.
you.
You're right.
Thank you
Thank
very
you.
much.
All right, we are on the record in the matter of the City of Wyandotte versus Reed Elson Duke, 251440.
Morning, Your Honor, John Goldwasser, P. 30758, on behalf of Mr. Alson Duke.
Thank you.
Your Honor, today was a date and time set for review in this particular matter.
Yes.
The last time we were here in court, and today, 2 weeks ago, we were contacted by the Forensic Center. He is scheduled for a evaluation tomorrow on January 8th. I've met with him and his mother. She will be responsible for getting him to the Forensic Center. He has all the documentation, everything. We're asking for an adjournment to go. We think, hopefully, the 28th, we may have everything.
Of January?
Yes.
We will not have that report back.
And-
It's a minimum of 30 days for them to type the report, typically. But Mr. Elson Duke, your name for the record, please.
We got 6 weeks.
Reed Sedgwick, Elson Duke.
Okay, thank you. Okay, so let's go slightly longer than 30
Yeah,
days.
fine,
Let's give them an opportunity
that's fine.
to, let's go with February 18th. So that's 1, 2, 3, 4, 5, 6. You're on that day.
I just want to make sure I'm going out of town at the beginning of February. Just want to make sure. That'd be
Yes,
fine.
I know, I'm not picking a date, you're not here. So the 18th is 6 weeks, so that would be,
That'd be perfect.
that should be sufficient.
That'll be fine.
Keep your hands out of your pockets, sir, please.
Can I record this?
Oh, you sure do.
Yep.
What time, Amy?
9:15.
9:15 a.m. Bond and conditions are continued.
Thank you, Ron.
Okay, thank you. Have a good day. Thank you. Okay, is Corey in here? Well, maybe it isn't Corey anymore. Are you Miss Byers? Miss Byers? Oh, you're Miss Byers. Okay. Let's go on the record in the matter of the City of Wyandotte versus Emma Patrick, 251429.
Good morning, Your Honor. Irene Byers for Emma Patrick.
Good morning. And your P number, counsel?
80001.
All right. 80001. Oh, wow, that's pretty easy to remember.
It is.
You work hard for that. Make sure you put it on every time. All right. And did you file, I know you filed an appearance, counsel, but we'll need you to grab a substitution of attorney only because there was, oh no, I'm sorry, disregard that. She's not been arraigned before, so we're all set. Okay, thank you. And your name, please.
Emma Patrick?
Okay, are you picking her up, Ally?
Yeah.
Okay, thank you for dressing appropriately for court. Can I get the date scheduled for the arraignment pretrial in this matter? And counsel as to the arraignment.
Your Honor, we've come to an agreement that the city will, with the prosecutor, that the charge will be dismissed.
Right, but first we need to do the arraignment on the original charge, and then we can handle the pretrial portion. So as the arraignment, do you want to waive the formal reading?
Yes, we'll waive the formal reading.
Okay, and enter a plea of not guilty?
Not guilty. Thank you, Your Honor.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And then as the pretrial counsel, you indicated there's been a resolution between yourself and the prosecution?
Yes, sure.
Okay, and if you can place that record, resolution on the record, please.
Your Honor, the disorderly will be dismissed and Emma Patrick will agree to plead responsible to the lesser citation.
Which is?
Your Honor, I did not write it down. I apologize.
Disruptive behavior?
Yes, Your Honor, disruptive behavior.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And you heard the very generous resolution your attorney was able to obtain for you, correct?
Yes.
As to the amended charge of disruptive behavior, how do you plead?
Responsible, Your Honor.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes, Your Honor.
You also understand by entering into a plea that you will be waiving some of those rights.
Yes, Your Honor.
You also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
No.
Okay. And so the court will find the plea is knowing and voluntary. The court will accept your plea to the amended charge, dismiss your original charge per the plea agreement. That's $250, ma'am. Do you have that to pay today?
Yes, Your Honor.
Okay, good luck to you, ma'am. Hopefully, this does not repeat itself.
Thank you.
Have a good day. Thank you. You can just stop at the window and somebody will be with you shortly, okay?
Thank you.
All right, we are on the record in the matter of the city of Wyandotte versus Michael Allen, 251712. Counsel, which matter are you here on? Oh, okay.
Your Honor, good morning. Richard T. Serrano, P33828, appearing on behalf of my client, Pierce to my right. And this is the date time set for arraignment pretrial. So please state your name for the record. Michael Allen.
Okay, and good morning. Today is the date scheduled for the arraignment. Sorry, the pretrial. Your client was arraigned on December 17th.
Oh, that's correct.
And counsel?
Your Honor, as to the pretrial, I've had a discussion with the prosecutor and my client wishes to have a discovery order signed by the court. We probably will have a resolution next time, but we sign that discovery order and adjourn the court.
Okay, sir, if you're to test right now, what is in your system?
And
Do you have prescriptions for, or are those over the counter? Okay. And I believe that you did not receive a written copy of bond conditions, did you?
No.
After you were released from custody?
No, ma'am.
All right. I had a visiting judge that day, so I would expect that that would be it.
And there was no tether order or anything of that.
Correct. Did you take care of your matter in the 33rd District Court, sir, that you have a bench warrant?
I'm still taking care of it.
What does that mean? You're still taking care of it?
Which one? That's Woodhaven.
It's in Woodhaven, but there's seven,
I got paid ticket.
but there's 7 communities that make that up. So this one's out of Trenton.
Yeah, I got paid ticket. That's fine.
No, you don't pay a ticket. You have to appear in court. It's not driving while license suspended unless you already pled and you just owe money.
Oh, I didn't have that. I didn't know I had that. I had a ticket, speeding ticket, man. Yeah. You go to the 33rd. I'll get there. Yeah, I'll get there. No,
So do you have 2 warrants, sir?
no, I had a felony probation for child support,
Right,
delayed sentence.
right. But you also have a matter out of the 33rd District Court from the City of Trenton Police Department for driving while license suspended. Do you have a valid driver's license, sir?
Yes, ma'am.
Okay, well, apparently in 2022, you may not have, I don't know, but you need to take care of that matter.
Yes.
That's going to be a condition of bond as well.
Yeah. Yes, okay. Yes.
All right, the court has signed the discovery order.
Thank you.
All right, Ally, actually. So January 28th, does that work for us, Ally?
And 10:15.
10:15, I believe she said.
Correct. And you'll get a copy of your bond conditions as well.
Thank you, Ken.
The court has signed the discovery order and counsel will get a copy of it shortly as well, okay?
Thank you.
All right.
Go to probation for the conditions, Your Honor.
Oh, you'll get a copy right here because
Oh, all right.
it's being adjourned. Yes, thank you. Yeah.
All right, friends, we're going to go back to the Louisiana board for our last segment of the day. But before we do, a couple of reminders. First, if you go to the pinned chat, you will find a link to our new show, In the Blind, with Mike and Dan. That's Michael Groff and I doing a show together. We're going to drop the pilot for that next week, and the first live show will be on the 2nd of February. I'm still stuck in last year. 2nd of February. But we'd love it if you would go over there and hit the subscribe button and the notification bell so that you're alerted and ready to go when we start doing shows over there. We're very, very excited about it. It'll be totally different from what you see here on TCF. But it'll have a unique twist, so I think you'll appreciate it. And speaking of TCF, just a reminder that starting next week, the show will start an hour earlier. So 9 a.m. Eastern, 6 a.m. Pacific. That starts next Monday, and we'll be having a 4th hour. That's why we're going that long. Michael says November would be a very long prep hype time. Yeah. I don't know. Time is hard, Michael. Time is very, very hard. All right. Let's go to Louisiana.
It is 1/7/2026. We're the board of, we're the committee on parole. And to my right is Mr. Jerry Ledoux. To my left is Chuck Tillis. My name is Steve Prater. We're in Baton Rouge. We're talking to Mr. Francis Smalls. Is that right?
Yes, sir.
Okay, Mr. Smalls, you're at Livingston Parish Jail. Is that correct?
Yes, sir.
Okay, and Deputy, would you introduce yourself?
Sergeant Jennifer Gomez of Livingston Parish Detention Center Classifications Division.
Thank you, Sergeant. We appreciate you hosting us for today. Mr. Smalls, do you, what is your DLC number?
780-732.
Okay, and do you have a waiver form in front of you?
As
that you signed?
Yeah, oh, yes, sir.
Okay, and you're wanting to go forward with this hearing, correct?
Yes, sir.
Okay, your case has been assigned to Mr. Chuck Tillis, who is on my left, and he's going to do the initial questioning.
Good morning, Mr. President. How are you?
How are you doing today, sir?
We have three violations, and we're going to go over them. Answer a plea of guilty, not guilty, or guilty or not guilty with a statement. Rule number 4, it's alleged that you engaged in criminal conduct which led to your arrest on 10/1/2025 by the Louisiana State Police for domestic abuse battery. How do you plead? Guilty?
Not guilty, sir.
With a statement?
Yes.
Okay. All right. Number 4, on 10/1/2025, subject admitted to recent, this is THC use. How do you plead?
Oh, guilty, sir.
Okay. And number 10, you're currently in the rear of $186. The last payment was made 8/19/2025 in the amount of $66. How do you plead?
Guilty, sir.
Okay. Tell us about the domestic abuse. What happened?
Well, a week prior to when my parole officer came see me on October 1st of my arrest date, my dad was, he had some illnesses going on. He caught the rhinovirus. And I had a mental breakdown because, he has 85% blockage in his lungs. And, I was having a mental breakdown and I had scratched my face. And also when my old lady came in there and she seen that, she told me to stop like 3 times and I wouldn't. I was so into my mental breakdown because I thought I lost my dad that I just didn't stop. So she went to beating on herself and choking herself. And a week after that, my parole officer came in there and he seen scratches on my face and marks on her. And he arrested me, sir.
So when she saw you scratching yourself, she started?
Yes. Yes, sir.
Okay. What about the drug use? You admitted guilty to that. That was during the time that,
Yeah, I had a medical card, but I figured out that I'm being on parole. You're not allowed to smoke THC. So I do admit to being guilty for that. You know.
You have a medical card for it?
Yes. I don't know. I could give you the name of the dispensary and you could talk to the doctor there, but I do have a card. Like I can go in there and I can purchase medical marijuana in my name and all that.
Okay. Any of my colleagues have any questions?
No, sir. I do.
Jerry?
Whenever you get a chance, if I can speak one more thing.
Sure, go ahead.
From what I recall, I think my charges did get dismissed. I'm not first say so, but from what I hear, my parole officer did come serve me and said my charges were dismissed. I just did want to bring that up to y'all's attention. I don't know if that's, that's all I have to say. I appreciate it though.
Thank you.
Yes, sir.
Well, I'm sorry to say that today my vote's going to be to revoke rules 4 and 10.
Yes, sir.
Ms. Jerry, are you ready to?
My vote is to revoke. But in my revocation, I want you to be placed in a facility that has a mental health evaluation capability. Health evaluation.
Where's that, Jackson, ma'am?
No, Elaine Hunt can do that, or one of the other facilities. Let DOC decide. I'm just going to require a health evaluation.
Okay, and my vote would be to not revoke, but you need 2 out of 3 of revocation. So sorry to say, but at this time at 9:53 in the morning, your parole has been revoked with the recommendation that you be sent to a facility that has mental health evaluations.
Yes, sir.
Denied. I still got to get that stuff set up. All right, guys, that brings it to a close for today. I hope you all had fun. I know I did. There's no better way to spend my morning than to hang out with all of you. That's why we're adding a 4th hour starting next week. Make it extra fun. The 4th hour will be cool, something different from what we do in the other 3, so be sure to check that out with us next week. Okie dokie, friends, go have yourselves a good Wednesday. I will see you all tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. And we will have sidebar tomorrow night, too. If you enjoyed the sidebar last night, it will be more of the same tomorrow night. We're going to do a part 2, so join us for that. And, of course, head over to In the Blind, link in the pinned chat, and subscribe to that new venture that will be starting up here real soon. So, again, go have yourselves a great Wednesday. Take care. God bless.